Sagla has said in 58, and the Parliament has thereafter, my lord, amended various laws to introduce what Justice Sagla has observed, my lord, in that Bombay 58 judgment.
Yes.
First is, my lord, would your lordship kindly see my written submissions in volume 1A, page 19, changes made in Companies Act.
Sorry, which page?
Page 19, my lord, I'm so sorry.
19.
Volume 1A, page 19, my lord. Wasn't there yesterday. Volume 1A, I'm so sorry. It's 19. Yes, it's a separate, complete compilation in a lordship drive.
It's a separate volume. Your
Yes, my
submissions are
lord. Yes,
separate
my lord.
volume.
My submission is separate. My lords have got it.
Just give me one. Just give me 1 second. I found it. Let's copy and paste it.
I'm so sorry. Mr. Bhushan has shown to your lordship, the 58 judgment where Justice Sagla say that we request the Parliament to look into it, this aspect of transparency and political funding of corporates. Heading of this page 19, my lord, would your lordship? Yes. Evolution of companies law, age-old practice of disclosure and the limit of donation introduced way back in 1960 overturned. No more disclosure required for donation made to political parties through electoral bonds. Lord, the first change was made by the Companies Act 1960, which inserted section 239 capital A in the Companies Act 1956, 293A. Yes. Lord, with this your lordship would find in volume 4, page 6888, this section 293 capital A.
Volume 4.
Volume 4, page 6888.
All right.
The amendment starts and the relevant section is 6890. 6890. It's section 293 capital A, my lord. It is introduced, Lord, exactly as advised by the my lord in the Bombay High Court judgment. Notwithstanding contained in section 293, neither any company in the general.
Oh, you want us to read that volume 4 now?
Volume 4, my lord. Yes, my lord. I'm just reading simultaneously.
Because we were on your written.
The relevant sections, my lord. Volume 4, page 6890. So. All of your lordships have got it, my lord. My lords have got it. Yes. Yes.
Learned brother Justice Khanna, that it's so heartening. In our court, everybody is on their iPads and laptops. I mean,
yes, no, that's only because my lordship insisted to impose that. Say that we'll impose a fine if we bring papers. So I've only got the bare act.
The files and the books have gone.
Yes. And it's
Well,
so convenient, my lord, initially.
was, my lord, the most technologically challenged person.
Yes.
But I am also, my lord, now on the.
All of us, my lord. And we initially thought when we were arguing in court number 2 that electricity matter, my lord, lordship insisted that no files.
Yes, what a
And-
huge
and-
matter that was, my God.
Yes, my lord. And that's the first time, my lord, when we struggled, my lord,
Yes.
we have to get into it. And Mr. Ranjit Kumar brought his even SCC, my lord. He said that I have to read from my SCC.
I remember.
But that's how, my lord.
See, the books have also gone from the flanks.
My
Because
lord.
we've been able to open up so
Yes.
much space for the bar,
Yes, Lord,
for
sir.
the law clerks, for the
Yes, my
members
lord.
of the,
Yes, my lord.
the public.
For the public and the interns, my lord, they are learning a lot.
Paperless
my lord.
court, my lord.
Yes.
Yes.
In fact, I just told my staff that we now court number 4 and 5 will also. 1, 2, 3, we have already done it, but now 4 and 5 will also. We were just going slow because we wanted to
Yes.
see how it is working, you know. Now we'll do it for 4 and 5.
And
then
now I
progress.
must tell your lordship, my lord, most of the high courts, my lord, after your lordship's last order has gone and started, my lord,
They have
all
started,
Guwahati High Court, my lord, my friend has said, my lord, now within a week, my lord, it is now in the daily list, my lord, all these links are there.
Why should
It
we
needed a
expect-
push and from your lordship, my lord, which has really worked. Please, your lordship, page 6890 is the, my lord, Companies Act Amendment Act 1960, which introduced section 293 capital A. And would your lordship kindly see, my lord? Notwithstanding anything contained in section 293, neither a company in general meeting nor its board of directors shall, exactly what Bombay High Court, after the commencement of the Companies Amendment Act 1960, contribute to any political party for any political purpose, to any individual or body, any amount or amounts which or aggregate of which will in any financial year exceed 25,000 rupees or 5% of its average net profit as determined in accordance with provisions of section so in the financial year preceding whereafter is greater. So, my lord, a complete cap of 5% or 25,000 rupees. Lordship would kindly see, my lord, clause 2. Every company shall disclose, this is not what is required for democracy, in its profit and loss account, any amount or amounts contributed by it under subsection 1 to any political party for any political purpose, any individual or body during the financial year to which that account relates, giving particulars of the total contribution contributed and the name of the party, individual or body to which or to whom the amount has been contributed. If any company makes a default in complying with the provisions of subsection 2, the company and every officer of the company who is in default shall be punishable with fine which may extend to 5,000 rupees. But what a great, my lord, transparency in the provision, my lord. And it's hardly, my lord, an advice given by your lordship's court, my lord, or by a high court, my lord, is completely incorporated in the provision, my lord. Now, my lord, after this, my lord, page 6895, this section gets amended, my lord, in 1969. In the same volume, page 6895, is the amendment of 1969.
when
Companies
does
Act Amendment.
293A come in?
I'm so sorry, my lord.
When does 293A come in for the first time?
Come in for the first time in 1960,
60.
after the 458 judgment.
Then comes the 1960.
Then comes in, my lord, 69 amendment. It completely prohibits from a corporate donation. 60, my lord, there was no regulated field. You can have in your articles of association, etc. 60, it is regulation has been made as to how and how much you can do it.
Mr. Ansari, just one clarification with regard to 293A.
My lord,
25,000 rupees applies to both A and B?
yes, 25,000 rupees,
Applies to both A and B or only to B?
no, to any individual, or would your lordship kindly see, my lord, any political, for any political party, to any individual, no, my lord, not
Or
with,
any political purpose to any individual or body? So political party is separate from individual or body?
no, it can be, my lord,
Both,
for
it
any
applies to
political,
both.
for any,
25,000 and 5% applies to both A and B.
to, my lord, to both.
Because
to
the
both.
way it's, way, probably you've taken a printout because it's a
In
old
any,
picture.
yes,
It may not be absolutely correct.
my lord, but then it was
Actually, there's a
understood that it,
comma. There's a comma
There's a
after
comma,
any
my lord.
financial year.
yes, will,
So that comma will seem to indicate that that exceed will apply to
it
both.
will
A
apply
and
to
B.
both, my lord, A and B.
It will apply to both A and
It
B.
will apply to
Otherwise,
both.
Yeah, absolutely. Yeah.
Yes, my lord.
Page one, sir. Page.
Page 6890, volume 4.
Otherwise, for political parties, there'll be a complete ban.
Complete
Yes,
ban. It will be
yes.
complete ban.
So
My
they
lord.
they didn't impose a ban, but they said 25,000 or 5%.
Yes, my lord.
Then came the 1969 amendment.
69 amendment, my lord, 6895,
Not apply.
which imposed the complete ban. Which imposed the complete ban.
6895, right?
My lord.
The reference to it in today's Times of India.
It was complete.
Not read the paper today. For section 3, my lord, of 69 amendments. For section 293, capital A, the following shall be substituted, namely, notwithstanding anything contained in the provisions of this act, neither a company in general board meeting or its board of directors shall, after the commencement of the Companies Act Amendment 1916, contribute any amount or amounts to any political party for any political purpose or to any individual. If a company contravenes, then punishable with fine or an imprisonment even, my lord. Lordship would see subsection 2, clause 2. Contravenes, every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 3 years and fine. So complete ban is imposed, my lord, in 69.
Then
Now, this ban is removed, my lord, in 1985, page 6897. The Companies Act Amendment Act 1985. 6897. Now, what my Lord Justice Khanna said, Lord, it is clear from this section now that it applies to both clause A and B.
the ban is removed.
293, my lord, which is substituted, namely, notwithstanding contained in any provisions of this act, no government company and no other company which has in existence for less than 3 financial years. Now, my lord, you cannot just create a shell company and contribute. So it has to be 3 years old at least, my lord. Shall contribute any amount or amounts directly or indirectly to any political party for any political purpose to any person. A company not being a company under clause A or B under subsection 1 may contribute any amount directly or indirectly to any political party or in so and so, provided that the amount, as the case may be in aggregate of the amounts, may be so contributed by a company in any financial year shall not exceed 5% of its average profit determined in accordance with the provisions of section 349 and 350 during the 3 preceding financial years. Contribution is restricted to 5%. So now the Companies Act 2013 comes, which is in the same volume at page 22. This provision of 1985 continues, my lord, till the new Companies Act comes in 2013. And volume 4, page 22, the pen 23, relevant is 23, section 182. Is the
23, right?
yes, my lord, page 23, section 182 is the my lord, new section for old 397A. 293A, sorry. 293A.
This is in 2013.
My lord, 2013 Act, my lord, yes. And that your lordship get at 22. Companies Act 2013.
Yes.
Section 182. prohibition and restrictions regarding political contributions, notwithstanding anything contained, any other provisions of this act, a company other than a government company and a company which is in existence for less than 3 financial may contribute any amount directly or indirectly to political party, provided that no such contributions shall be made by a company unless a resolution authorizing by making such contribution is passed by the board of directors, and such resolution shall be subject to further provisions as deemed necessary, etc. Then, my lord, 2, without prejudice to generality of subsection 1, a donation or subscription or payment which is caused to be given by a company on its behalf or on its account of a person to its acknowledgement shall carry on any activity at a time such a donation which is given, my lord, not relevant. Clause 3 is relevant, my lord. Every company shall disclose, this is what has been given a go by, my lord, in its profit and loss account, the total amount contributed by it under this section during the financial, Lord, this is, my lord, the amended section of 2017. Unamended section, Lordship would get in Mr. Bhushan's, my lord, compilation, which is in volume 1.
So,
Would your Lordship kindly come to, my lord, volume 1 for a minute? my lord.
just 1 minute. This is 182 at page 23 is what?
Is the Companies Act, my lord,
2013.
2013 as amended in 2017, my lord. I'm so sorry. But that unamended provision is not there. It is in Mr. Bhushan's compilation, volume 1.
This is after the bonds,
After the bond, yes, my lord.
which is volume 1 now. We go to volume 1 now.
I think 2000.
Where is that amendment? Yeah.
182 is in volume 1.
Lordship would give me a minute, Lord. That is Companies Act is not good. Yes, page 7, my lord. Page 7, volume 1. Yes, my lord. Volume 1, page 7. Volume 8.
Page 8.
Yes, my lord. Page 8. 182.3 is very important, my lord. Page 8. I'm so sorry. I'll come to this.
The original section 182 had this cap of requirement of 3 years existence and 7.5% of its average net profit.
My lord, my lord. And contribution by electoral bond not to be disclosed. 3A. Lord, may I just see, Lord, my lord,
Why are you going to the electoral bonds right now?
No, and I'll come to it, Lord, because that is the proviso which says that any bond issued under the
Will
government
not be disclosed.
will not be required to be
We are
disclosed.
now looking at the act as
Act-
it originally.
Yes,
So
my
let's not go to electoral.
Let's
bonds right
not
now.
go
We're
into
trying
that.
to understand the legislative
Let-
history prior to electoral.
Yes, my lord.
bonds.
My lords, I'm correct. I'm grateful to your lordship. So,
So
my
we'll
lord,
look at page
page 8,
The first
left
one.
hand column.
The left-hand column.
3 things, my lord. 182.1 proviso requires it shall not exceed 7.5%
Right.
of its average net profit for the 3 financial years. That is the requirement number 1.
Yes.
Requirement number 2 is 182.3. Every company shall disclose in its profit and loss account any amount or amount contributed to any political party during the financial year. It relates. Now, next is important. Giving particulars of the total contribution made and the name of the party to which such amount has been contributed. So, my lord, 2013 Act.
Right.
Now, 3 things, 7.5%, and my lord, particulars of the party to which you have contributed. Now I come, my lord, 2013 to complete the scheme of the Companies Act, my lord.
now look at the 2017.
17, Lord, on the right-hand column.
Which,
My lord, first, it deletes the requirement of 7.5%. Proviso is deleted.
yes,
Subsection 3 is substituted, my lord. Subsection 3 is substituted,
yes.
and the substituted section says, omits the requirement of giving particulars of the amount and the name of the party to which has been contributed.
Yes, we got it.
Subsection 3 is inserted to 182. May I read that? 3A is inserted. Answers, yes. Notwithstanding anything contained in subsection 1, the contribution under this section shall not be made except by way of account pay check drawn on a bank or an account pay bank draft for use of electronic system through a bank account. So very loud, you cannot make cash payment basically. Provided that a company may make contribution through an instrument issued pursuant to any scheme notified under any law for the time being in force for contribution to political parties. Subsection 3 substituted deletes the requirement of giving the particulars of the political party.
Just one.
I'm so sorry.
Even if it's deleted, there is no other requirement, there is no mandate that it should not be disclosed.
Yes, my lord. There was a mandate you must disclose. Now that mandate is gone,
Just one.
my lord.
See, the accounts under the Companies Act
Yes, my lord.
are maintained for the purpose of ascertaining the real income.
My lord.
These are different from the income tax account.
Yes.
Normally, under the Companies Act, the tendency is to overstate the profits. Because then you get more credibility in the market.
Yes, more
You have
funding.
more access to credit.
Yes.
Whereas it's opposite in the income tax act.
Yes, my lord.
There is a tendency
The tendency is to reduce so that you pay less tax.
to save tax. But in this case, even if it is deleted, you have to disclose the amount which has to be paid. 2, there is a requirement for the board of directors resolution to be passed.
My lord.
The boards of directors resolution will contain the name of the political party or may not contain the name of the political. But there is no express bar to not disclose.
No. There is no bar, my lord, but there is no requirement, my lord. If the law has been changed, my lord, a requirement is deleted. Presumption would be it's not required to be disclosed. The interpretation would be, my lord, otherwise, the substitution of section 3 is meaningless, my lord. Substitution of section 3 is, my lord, with a new subsection, that you delete the requirement
What
of
is new subsection 3?
subsection 3 is, my lord, substituted with on the right hand side.
Page 8.
Page 8, my
on
lord,
the-
all of your
Every
lordship.
company shall disclose in its profit and loss account
Yes,
the
total
total
amount,
amount contributed by it under this section during the financial
that's
year.
all, my lord. Yes. The disclose. I've
In
contributed
fact,
X amount.
The words any
Yes.
is.
And
is
any amount or
substituted.
amount.
It just says, instead of any, it says total amount contributed by it under this section.
Please, your lordship.
Earlier provision was any amount or amounts contributed by it to any political party during the financial year.
My lord.
The reference to the political party is taken away first in
Please.
182.3.
Yes.
And it just says any amount contributed under this section.
Yes.
Secondly, that what is deleted is giving particulars of the total amount contributed and the name of the party.
Name
to which
of the
such
party,
amount
yes.
has been
So
contributed.
they just say I contributed for political parties X amount.
By inference, it can be implied inference, it can be drawn that the name need not.
Need not be disclosed.
Yes, not required. That's the whole purpose of this, my lord. And when your lordship see this,
The party need to be no name of the amount to be
The
disclosed.
total amount.
Not
X
the-
amount.
Yes.
X amount is to be paid for political,
Acceptable,
X amount is paid for political contributions. That's all, my lord.
You don't.
Because 180 to 1.
You merely say that I've contributed 100 crores for political contribution.
That's all.
But you don't have to either give a bifurcation or name the party to whom you are.
Yes, my lord. Yes.
So it becomes now an anonymous.
Completely, my lord. And because you get a tax exemption, 80 GGB, you get the complete tax exemption of whatever you have contributed to political contribution.
Otherwise, it won't be covered by 37.
Yes.
Until somebody claims this.
100%, my lord, to a charitable trust, we get 50%, my lord, under 80G. And there's a cap, my lord, I can contribute only 10% of my income to the, for a 50%.
Purpose.
There's a cap for a charitable purpose. To political parties, I can contribute any amount and get 100% deduction.
All right, we got that.
Yes, my lord. And proviso lordship has seen, my lord.
Yes.
So now, my lord, lordship may come back to my submission, my lord. This is what the Companies Act amendment has done.
So now we are on volume 4.
Volume 1A
Sorry,
again, my
you are
lord.
in
I'm so
volume
sorry.
one.
Volume 1A is my
Yes,
submission.
Yes, of course.
Page 20 and 21 are my submissions on what has happened to these changes.
19 now.
Yes, my lord. Your lordship has
We have
seen, my
seen 20.
lord. 16, 17 and 18. Lordship has noted it from the volume 4. The changes made.
Would you like to read para 19, Mr.
May I read para 19, my lord?
I think that's
Yes,
your submission.
that's my submission, lord.
Yes.
Thus, the companies all along, since 1960 till 2017, have been mandatorily required to disclose not only the amount contributed, but also the name of the party to which contribution is made. Further, there has always been restrictions such as the ceiling that the contribution shall not exceed the prescribed limit 5% under the Companies Act, 7.5% under the Companies Act 2013 of the average profit of the past 3 years. By virtue of the said condition, it was ensured that the shell companies were not able to make contribution to political parties. The above conditions have thus helped to ensure transparency in political funding. The fact that such provisions, said provisions of section 293 capital A equivalent to section 182 of the COP help to achieve the objective of the transparency has been acknowledged by this honorable court in the case of common cause. Lord, I've given the paragraphs. I'll give it to your lordship, the paragraphs of this judgment. It is pertinent to note that when Finance Bill 2017 was initially presented, there was no proposal to dispense with the aforesaid conditions. However, the Finance Act 2017 amended section 182 and conditions to disclose the name of the party and the ceiling of the amount permissible contribution was dispensed with. After the commencement of the Finance Act 2017, now what is the position now? A company is now only required to disclose in its profit and loss account the total amount contributed by it, without being required to disclose the name of the party to which the amount is being contributed. Thus, the company may only require to declare that X amount has been donated without any details, which makes it impossible to trace as to which party is being funded. Even the shareholders may not know. Funded to which the corporate entity, making the corporate funding vulnerable to gross misuse and abuse. There is no ceiling on the contribution made. Thus, the contribution may be made dehorsed probability. Shell companies as well as loss-making companies can make contribution to a political party.
That's fine.
One level,
My lord,
all this has been regulated by statute,
my lord,
right? Right from 1956.
my lord,
The nature of the regulation has been by statute.
my lord.
The only point is this: absent an enabling provision in the statute, namely the Companies Act, no company can donate for political purposes at all,
Yes,
right?
yes,
So though at a certain level or at first blush, this is regulated by statute.
My
What
lord.
is conferred by statute can be taken away by statute. All right. No implication of a fundamental right can arise. So for instance, just wait a minute.
my lord, my lord.
It may not be against you.
Yes, no, I'm.
Suppose there was no provision in the 1956 Act
My
at
lord.
all for political contribution. What would be the consequence? Consequence is not that companies are free to donate for political purposes untrammeled by any other provision. The 1956 Act, for the first time, when that enabling provision came, provided, in fact, there was a complete ban. 1960 was 5% of the net profits or
Yes.
20,000 rupees.
My lord,
Absent that provision, you could not have contributed at all.
my lord,
Then comes the ban in 1969.
69,
Ban is lifted in 1985.
85.
So though it is a matter of statutory regulation,
Yes,
absent an enabling provision, a company cannot contribute to
My lord.
political purposes.
my lord,
So if the constraints subject to which those contributions are permissible are lifted by the legislature,
My lord.
they are amenable to be tested under Article 14.
Article 14, yes, my lord. And it is manifestly arbitrary, my lord. There are two reasons which are given.
So it's not just a question of what the legislature enacts, it can take away. There's
No,
no
it
fundamental
is
right.
not like that, my lord.
But
Yes,
when you are making an
This-
enabling provision
My lord.
for contributions
my lord,
and taking away the restraints on companies,
yes.
the taking away of those restraints is amenable to be tested.
Is
under
unable
Article
to be
14.
tested on manifest arbitrariness, my lord. Because, my lord, there are two objects which are given. To give transparency, I'll show to your lordship that only two objects which are given, my lord, for amending
That we have
this.
seen
No, my
now.
lord.
I mean,
Lord, it has-
transparency
Lord,
and other things you
very
need
well,
not
Lord.
repeat because that your predecessors all argued.
Very well. So it is amenable to be
But this was
tested.
very valuable because you have given us the complete
My
legislative
lord, I'm
history.
grateful to your lord.
Now, what do we from here?
Now, would your lordship see similar changes in the Income Tax Act?
All right, let's see the income tax.
Yes, my lord. Which are in, my lord, page 12 of my same compilation,
Well,
my lord. May I read, my lord? This is 70 page, no. इसी में कोट किया हुआ, okay.
yes.
What? Heading D, page 12.
D, yes.
Evolution of income tax benefits in the context of political parties. I'm so sorry. Yeah, my lord.
Yes.
Evolution of income tax, page 12 of volume 1A. Benefit in the context of political party amendment to not to keep the records and yet granting tax benefit in contradiction to the initial object behind introducing such benefits. Now, section 13A was introduced in the Income Tax Act 1969 in 1978, whereby the income of a political party inter alia from contribution received was exempted. The exemption was provided to address the issue that such taxation of their income reduces their disposable funds, adversely affecting their capacity to finance their activities from the legitimate source of income. Then, my lord, I have quoted the objects and regions. Lordship may just skip over and see the top of it, page 13. Now, that was regarding the Companies Act. Now, this is regarding, my lord, the political parties. Of page 13, exemption will not be allowed unless the political parties maintains proper books of account, records the name and addresses of every person who has made voluntary contribution of
This is a
more than
statement of
10,000.
objections. You're reading the statement.
I'm reading, my lord, statement of reasons, my lord, then I'll come to the section, my lord. I just and accounts political audited by the chartered account, and then section 13A inserted by 1978. Special provisions regarding to income of political parties. Any income of political party which is chargeable under the head interest of securities or interest from other sources, or any income by way of voluntary contribution received by a political party from any person shall not be included in the total income of the previous year of that political party, provided, no, my lord, it's exempted provided, these provisos are important. Such political party keeps and maintains such books of account and other documents as would enable the income tax officer to properly deduce its income therefrom. Lordship has seen yesterday, Mr. My learned friend Paratha said, one DV, KV has given 1 lakh, and that is exempted, my lord, without details. My lord, my submission would be, my lord, when it comes to the scrutiny of the political party's income, my lord, nobody applies its mind. The income tax officer should have said, my lord, you are required to disclose details. Accept cash of 1 kb, my lord, of 1 lakh rupees. Page 5553, my learned friend Mr. Farah has showed that, my lord, to your lordships. And that is accepted. Whereas the requirement of Income Tax Act that you must books of accounts so that the income tax officer properly distributed income from. Second, in respect of such transaction in excess of 10,000 rupees, such political party keeps and maintains a record of the contribution and the name and addresses of the person who made the contribution.
What is the next, thereafter, what is the
Yes,
change
my lord.
made?
And my lord, this, then political, then this, my lord, has been changed in 2003.
Where is that?
Next page, my lord, page 14. And my lord, I have quoted the statement of objection regions that may not be lordship, may not, or I can read that, my lord, because 2003, as the large number of changes in the Income Tax Act, my lord, and the Electoral Bond Trust, my lord, I'll invite your lordship's attention as it came, my lord, it was introduced. To keep the identity of the donor, my lord, which is being said corporate houses to be secret, my lord, not to go in public domain, etc. The purpose of one of the things is said that has been taken care of by Electoral Trust. In 2003 amendment, my lord, the objection regions, Law Minister's statement is quoted. Lordship may skip over that. I have given the region, my lord, as the bold portion. May I read, my lord, at page 15, the bold portion, middle of it. Just get me the Income Tax Act. You have the Income Tax Act. Income Tax Act.
Let's read this para 10, basically it gives sums up what happened.
Yes, my lord. Para 10.
So till 2003, there was no equivalent of 80 GGB and 80 GGC.
Please, your lordships.
So at that time, therefore, they will not, these donations will not be covered by section 37 of the Income Tax Act.
Yes, my lord. No, section
37
13A.
is the expenditure clause.
My lord,
They will not be covered. It's not wholly.
the
exclusive.
donor will not get, my lord, the exemption.
Donor will not get the exemption.
Yes, the political party is receiving, my lord,
They are exempt,
their income is exempted provided those conditions are met.
satisfied.
But the donor
But
will not get it.
Donor, it was not treated as expenditure in the hands of the donor.
Please, your lordship. And 80 GGB and 80 GGC. Would your lordship see this section, Lord? It's not available on record, my lord. I have given the books.
Who uploads karo 80 GGB or 80
Yes, I have
GGB?
given in the one. Who? Isme hai? No, we have given the list. Anyway, it doesn't matter. My lord, may I just read the summary of it, my lord, and in the meantime. Yes, it is. Yes, it's there. I have. Yes, my lord, may I read para 10? Made the following major amendment. 80 GGB and 80 GGC was inserted to provide that. I'm so sorry. My lord. Objection. Section 80 GGB and GGC were inserted in the Income Tax Act to provide that the contribution made to the political party shall be deductible. That is, whatever is the amount contributed, a deduction is admissible to the expenditure of or that amount so contributed would be available to the donor under the Income Tax Act. This was intended to incentivize persons to give donations to the political parties by check, and these donations were also disclosed under the Companies Act, Lordship has seen. Well, Lord, may I just pause here and if come on. Section 80 GGB. It's here.
Yeah,
Okay.
got it, yes.
Yeah. May I read that, my Lord? It is there in your Lordship screen. Lordship would get it the footnote inserted by Act 46 of 2003. Deductions in respect of contributions given by companies to political parties in computing the total income of an SSC, being an Indian company, there shall be deducted any sum contributed by it in the previous year to any political party. Look, let's stop here. That is it in 2003. The next part has come in 2017 or 2009. That is the Electoral Trust. I'll come to that little later. And 80 GGC, that is companies, GGB is company, and GGC is individual. Deduction in respect of contributions given by any person to political parties in computing the total income of an SSC, being a person except local authority so and so to any political party.
All right, so we got this, the 80 GGB.
Yes, my Lord. So,
Now
my Lord,
next.
in 2003, exemptions are given to the donors also, my Lord.
Right.
So we can donate any amount of money, exemption, my Lord. Now comes, my Lord, 2009.
Yeah.
That the scheme of electoral trust is introduced, my Lord, by inserting section 13B. 13B.
In which year?
Section 13B, my Lord, 2009. Any voluntary contribution received by an electoral trust shall not be included in the total income of the previous year of sub-trust if such electoral trust distributes to any political party registered under section 29 capital A of the Representation of People's Act during the previous year 95% of its aggregate donation received by it during the previous year along with the surplus, etc. May I just explain the scheme, my Lord? So 5 companies can create an electoral trust. You make the company makes a contribution to the electoral trust. It reflects that I have made a contribution to the electoral trust. Those pages are here, my Lord, unfortunately in here, to a electoral trust. The company's account will show that only. And, my Lord, and the electoral trust must make 95% of its contribution to the political parties. It gets, my Lord, deductions completely. So through that route, my Lord, companies can make donation to the political parties.
Yes.
And 80 GGB and 80 GGC is also amended in 2009 to show, my Lord, that any donor to the electoral trust also gets an exemption.
Yes.
And Lordship may only make a note, my Lord. Rule 17CA of the income tax rules, my Lord, makes the detailed provisions about how to electoral trust is to be function, my Lord, maintain, etc. account details. So the scheme is, my Lord, in 2009. Make an electoral trust. Company make donation to the electoral trust, you get an exemption.
5 companies could set up an electoral trust.
That exactly has happened, Manoj.
And was there any restraint on how the electoral trust should contribute to a political party, or they could contribute to any
electoral
political
trust,
party?
but it has to mandatorily contribute 95%.
But was there a requirement of disclosure, maintaining accounts, etc.?
That is there in the rules, my Lord, in 17CA.
Rule?
Rule 17CA of the income tax rules changed in 2013. The complete thing is made in
No,
2000.
this provision was incorporated in 2000, was enacted in 2009.
Yes,
So the rules must have been made at that time itself.
Or they came at the first time.
I'm sorry, my lord, I couldn't get.
The rules must have come in at that time itself. Was there any restriction as to the quantum of donation which should be given to a particular political party? Was it restricted on the basis of the
No, my lord.
electoral
No,
share?
basically idea was, my lord, the corporate identity
share?
may not be disclosed.
No, that's fine.
So this is
But
the route.
For the outgo, was there any restriction as to whom it should be across the board, or it was restricted only, it was complete? You had the option to go to any, give it to any political party.
Electoral trust, my lord, has to be, my lord, the formulation has to be approved by the income tax commissioner, etc. Rules have said.
No, but the point is,
Yes,
would
ma'am.
an electoral trust say that we are going to give money only to one political party?
Yes.
Or was there, let us see that rule. You
Yes,
said
ma'am.
rule
Put-
17CA,
It can
Rule
be given to
17
one party also.
one party also.
That I have the, my lord,
No, there was no restriction.
there was no restriction. Instead of 5 people differently donating,
They
they
all
create
gave
a
it to an
trust.
electoral trust.
There are some 28 trusts and that scheme still continues.
Right.
But
Yes.
it was found to be a non-starter.
It
No.
was, we
I'll
come
show
to
the
that,
figures.
but there was no restriction that you had to equally distribute
No,
or,
no, no, no.
or proportionately distribute.
No, no, no.
between
But like-minded, my lord,
Rules
people
made.
can come together, create a trust and donate to one party.
17CA.
I don't know, I got some impression that probably there was some proportion.
Lord, I can, my lord.
Let's
No,
check it up.
no, we have the figures on record. I'll show to your lordship.
No, no.
Electoral trust figures are on record.
Collectively, they may have given to different parties, but there was no rule,
No
prohibition or embargo
All right.
that they have to equally distribute.
No.
They can give to one party.
Let's see that rule 17ACA,
Sim-
because 13B, subclause B says, such electoral trust functions in accordance with the rules made by
My
the
lord,
central government.
that's the rule 17CA.
Now let's see what that rule says.
Yes, my lord.
Rule 17CA upload kar dijiye zara.
Nahi, I think. Rules are not there, my lord. They're not online. You have it online? Can you share it? We have it online. Link. Is it?
Yeah, give the link to him, he'll do it. Share.
Can share it?
Sanjay?
Can we share it?
But
हाँ. आप आपको लैपटॉप दे सकते
I can adopt that.
Can we mail to your lordship that ID, my lord? Huh? Mail.
Mail it to the court master, no problem.
Yes, mail it to court. Only 39, 17 CA.
बंद कर दो जरा, second mic बंद कर.
Very good. Would you send or I can send?
Your
The
control.
functions of an electoral trust.
Your morning.
Site of.
Oh, that, it said the electoral trust shall not accept any money from, I just missed it here, from any foreign entity, whether incorporated
Yes,
or not.
yes. So foreign entities come now, my lord. I'll show to your lordship, presuming the FCRA regulation is valid. Even in defense sector, my lord, they can pump any amount of money, defense companies. Yes, it has come on. If your lordship see, my lord, 1 to 6, who said, electoral trust can accept money from whom?
थोड़ा scroll कर लीजिए नीचे.
7 is possibly answering your lordship's questions.
7 दिखना, हाँ, थोड़ा सा ऊपर जाइए बस. नहीं, ऊपर और. Political party. रुक जाइए.
Only to eligible political parties.
And
29A.
7. A
Spend
politic-
up to 5% of its total
No,
contribution.
because 95% you have to contribute, 5% only you can keep. 7 is important and 8 is important. First, Lordship may permit me to read 7.
Just read 7.
Yes, my lord. A political party registered under section 29 capital A of the RP Act shall be an eligible political party, and electoral trust shall distribute funds only to the eligible political parties. So, my lord, you can distribute, my lord, to whichever political party, but registered under 29A. I'll come to the scheme of RP Act. 8. Electoral trust may, for the purpose of managing its affairs, spend up to 5% of the distributions received in a year, subject to an aggregate limit of 500,000. You can add up. Also. Okay. In the first year of incorporation, rupees 3,000, 300,000 in the subsequent years. I'm sorry. भी कोई है इसमें relevant?
Fact that in the Election Commission of India,
Well,
then issued a directive. They issued a directive after this rule was brought into force,
my lord.
mandating a disclosure by political parties of contributions which were made.
My lord.
Once the Election Commission of India mandated an exercise of its powers under Article 324
Yes,
that there should be a disclosure,
yes,
then this became a non-starter because then you had to come up into the public realm
yes.
on what you have donated.
No, but my lord, they have distributed the figures. I will show to you, Lord.
Right, we'll see that.
Figures are there on record. Page. That distribution amount.
Yeah.
May I read, my lord, two more sub rules of this, my lord? This is very important. Sub rule 9. Trust shall obtain a receipt from the eligible political party indicating the name of the political party, its permanent account number, registration number, amount of the fund received from the trust, date of the receipt and the name of the designate of the person signing such receipt. Electoral trust shall not utilize any contribution for direct or indirect benefit of the members or contributors for any purpose, namely executive, etc., etc. Corporate entity cannot use it, cannot give it here and then use it for their own purpose.
Then the electoral trust shall also maintain a list of persons from whom contributions have been received
Yes,
and to whom the same have been distributed, containing the name, address, and permanent account number of each such person, along with the details of the amount and mode of its payment, including
yes,
the name and
yes.
branch of the bank.
Yes. Electoral trust has also maintain a list of persons from whom contributions have been received. I'm so sorry. From whom contributions have been received and to whom the same has been distributed, containing the name, address, or permanent account number of the person, as well as details of the amount and mode of payment, including the name of the branch of the bank. 12. Every electoral trust shall get its account audited by an accountant as defined in explanation to section so and so, along with so and so. An electoral trust shall maintain a regular record of proceedings of all meetings and decisions. 14. Electoral trust shall furnish a certified copy of the list of contributors and a list of political parties to whom such sums were distributed in the manner prescribed in Subrule 8 to the Commissioner of Income Tax or the Director of Income Tax, as the case may be every year. So, my lord, the income tax is there, election commission, my lord, by virtue of that, it is
I
there.
don't think, subject to correction, I think the rules were introduced only in 2013.
My lord,
So till 2013,
Yes.
the 2009 amendment was.
electoral
never-
trust route was not available.
So it was never got enforced.
And now, after being
Conformity
available
with the rules, because it had to function in accordance with the rules.
in accordance with the rules. So,
So
still
long
the
the
rules
rules
are
were
there.
not formulated, there was
Yes.
no guidance in the
Yes, my lord.
functioning.
And if your lordship now see, my lord, how many electoral trusts has been formed, etc., that is in volume 4, page 7311.
Volume 4.
7311 is an analysis of electoral trust contributions by ADR for the year 2015-16. Yes, 7311, volume 4.
There were total 18, but
Yeah.
8 didn't receive anything at
If your
all.
lordship see below page 7134, the contributions, there are 18 electoral trusts who have contributed 49 crores, roughly. So solicitor saying it didn't work, my lord, that the route which, because it was transparent enough. Corporates cannot, my lord.
Basically, there's only one trust which had substantial.
Yes, my lord, that's
47
only one trust, my lord.
Satya.
Satya Electoral Trust. The total is 49 crores, my lord, only 47 crores is by one trust. To whom, my lord, 5 corporates houses may have donated money or contributed money. This is for 2015-16.
They must have that pass.
18-19 it improves, my lord, which is figures are at page 7326.
But that gap under the company.
Seven three two six, my lord, in the same volume, volume 4, is the analysis for 2018-19. At 7335, give the figures, my lord. There are 25 trusts. And my lord, the total figure is at page 7335, 252 crores. There also, my lord, now some other prudent electoral trust contribute the major part of it.
25 trust, is it?
Yes, my lord. And these are available, my lord, on with election commission. My lord, election commission has a very important role. Now, my lord, with this scheme, election commission has been completely shut out of all information. That's why your lordships have passed that interim order. I do not know, my lord, whether the election commission has brought those details to your lordships, my lord. But they said in the subsequent order, we have it, we have kept it in seal cover. And lordship would see, my lord, in the yellow, not available on ECI website, even 5 electoral trust or 6 electoral trust does not give it, my lord.
All right, then
So, my lord, now the final amendment is lordship would get it, my lord. 2009, your lordship has seen the amendment. Now 2017 amendment, my lord, which your lordship would get in Mr. Bhushan's note, my lord, volume 1. At page 8, bottom. A is amended by 2017 Finance Act. And the amendment is on the right hand side at page 9 of volume 1. I know. This is the existing provision, my lord, till 2017. Lordship has seen 13A. Now on the right hand side are the changes made in bold. So earlier requirement was, my lord, you have to disclose every contribution in excess of 10,000 rupees. Now it says on the right hand side, clause B of proviso, because they can get exemption or deduction, my lord, only if they fulfill these conditions ABC till 2017. And 2017, this 7 ABCD. CB has been changed in respect of voluntary contribution other than by way of electoral bond. Now it comes, my lord, that if you make changes or contribution other than electoral bond, you will be eligible for exemption. So you don't have to give the details of the electoral bonds. That is one change made, my lord, in clause B. Second change is, my lord, clause D is added. No donation exceeding 2,000 rupees is received by such political party, otherwise by an account pay check drawn by a bank or an account pay draft or use of electronic clearing through a bank statement or electoral bond. So, Lord, you cannot pay cash in excess of 2,000 rupees now. Earlier, you could have received cash, my lord, but you have to give the details above 10,000 rupees.
yes.
Now, my lord, D is important that you can receive, but otherwise then electoral. And what is electoral bond is explanation, my lord. For the purpose of this proposal, electoral bond means a bond referred to an explanation to subsection 3 of section 31 of the RBI Act. Now, lordship would immediately come to page 10. What are the changes? Because it says, as defined in the RBI Act. Now, what is the change in the RBI Act? Lordship would get at page 10 of the same volume, volume 1.
Yes.
Now, my lord, section 31 is the, my lord, of RBI Act 1934. Issues a complete ban on issue of demand hundi, my lord, promissory note. And this, in fact, my lord, gives in your hand an electoral bond. I can valid for 15 days. I have a currency to print myself, my lord, electoral bond. I take it. I'll show to you, lordship, how it works.
Yes.
Yes. I will show to you.
I can print.
I will have it in my hand as I want. As is cash. I don't print it. The scheduled bank prints it. I know that.
Telgi, if you.
Yes.
Yes.
Notwithstanding, what is added is subsection 3 in the RBI Act. Notwithstanding contained in this section, the central government may authorize any scheduled bank to issue an electoral bond. Explanation: for the purpose of this subsection, electoral bond means a bond issued by a scheduled bank under a scheme notified by the central government. So, and that bond scheme, Lord, Mr. Bhushan has shown to your lordship, Lord, how it works. State Bank of India can do it valid for 15 days. What I'm showing to your lordship, my lord, the details of these donations by electoral bond is done away with by section 13A amendment, clause 4. Proviso, clause D added to proviso of 13A.
Right.
So, my lord, no longer the disclosure of the
So now we-
receipt
yeah.
amount by electoral bond.
Yes.
Now, fourth change made is in the Representation of People's Act, 1951. Which is there at page 7. Excuse me for a minute. Lordship may only make two notes, my lord. Representation of People's Act, section 29, capital A is inserted, my lord, in 1989. Till then, my lord, there was no provision for political parties so far as, my lord, statutory recognition. 29A, which is in
Fancy.
volume 4, page 27, it is there, my lord. That 1980, chronologically, let me go to it, my lord. 1989, section 29, capital A is inserted.
Volume 4 page.
Volume 4, page 27.
All right. Provides for recognized political parties.
Yes, my lord. Statutory recognition of political parties by the RP Act, which your lordship will get, volume 4, page 11 it is.
Volume 4 page.
Lordship, this starts at 27, lordship, at 46, my lord. Yes. 1989, this section is added. Page 46.
Yes.
Registration with Election Commission of association or the bodies as political party.
We
in
didn't read the
association
whole
of-
thing. We just.
That's all right. No, general, I'll just giving the history, my lord. Then 2003, along with those changes in the Income Tax Act, my lord, section 29B and 29C are added at page 47. 2003 is a very lot important for the making the donations to the political parties. 29B permitted political parties to accept contribution from companies, but no contribution from foreign source. And my lord, what is important is 29C, that they have to give reports of contributions in excess of 20,000 rupees. And details would mean, my lord, the details of the persons of identity, not KV. 29C, my lord, just treasurer of political party in respect of any person authorized by political in this behalf financially report the following: the contribution in excess of 20,000 received by such political party from any person in financial year, meaning therefore you can identify the person. The contribution in excess of 20 received from political party from companies other than government company. Now, my lord, the 2017 change comes, my lord, which your lordship will get in volume 1 at page 7.
Get it any actually. So we'll see.
Now, do lordship come to page 7 of volume 1, where the corresponding changes have been given in the tabulated form by Mr. Bhushan, my lord. 29C earlier required details of all contributions beyond 20,000 rupees. Now, proviso is added, my lord, to 29C, subsection 1. Provided that nothing on the right-hand side bold contained in subsection shall apply to contributions received by way of electoral bond. So you don't have to give details. For the purpose, electoral bond means RBI Act. So, my lord, this has been done away with. So this is the complete, my lord, the scheme of the 4 enactments, my lord, lordships are concerned with. The Companies Act, the Income Tax Act, the RP Act, and the Reserve Bank of India Act.
Thank you, Mr. Ansari. Anything more?
Yes, my lord. One more thing, my lord, which is important. One of the arguments is, my lord, the disclosure is required of the candidates, not of political parties. Now, my lord, if your lordship permit me to come to my written submissions at page 35, just two paragraphs of that.
Originally, our law really didn't speak of political parties at all.
Yes, my lord.
The Constitution incorporated the concept of a political party when the 10th schedule came in.
My lord, yes.
Before that, we really spoke of the right
Yes.
to suffrage, which we saw Article 326.
Please, your lordship.
The individual right to contest an
Yes.
election, the individual right to stand for election.
An individual right of a legislator to vote as per his conscience is also taken away. But political party can issue a whip.
29A is inserted in 1989.
To
For the
recognize.
first time, the law takes into account specifically
My lord.
the very concept of the requirement of registration.
Yes.
Of course,
Symbol.
allotment of symbols was always
68.
there. 68.
68 symbol order. So would your lordship just permit me to show 2 paragraphs of page 35, my lord, of my written submissions, which is volume 1A. Page 35, para 42 and 43. Volume 1A are my written submissions, my lord.
Yes.
Para 41, my lord, 29A, lordship says seen. Political parties are the central institutions of democratic form of government under the Constitution. The sovereign will of the people is expressed through its representative, most of whom are set up by the political parties. Political parties are the route through which the voice of the people is expressed in the parliament. Since the political parties play a central role in the democratic setup, they must function in transparent manner. More particularly, there must be financial transparency to ensure purity of election. The political parties are the organizations representing the hopes and aspirations of the people. Now, 43 is important, Lord. The political parties are entitled to various benefits and privileges, some of which may be noted as hereunder. First, my lord, lordship has seen, Lord, their contributions they received under 13A are not taxable. The donors also get exemption under GGB and GGC. A is, my lord, 13A. Clause B of para 43 is 80 GGB and GGC. C is, my lord, the election expenditure. The political parties, my lord, which incur are not added to the candidates. So that's again, my lord, important thing which benefit received by the political parties. All these are to show that political parties perform a very important function in the democratic setup. Fourth, my lord, D, under the 10th schedule, as your lordship has said, my lord, they are bound to vote as per the whip of the party, irrespective of their conscience of the, otherwise they are incur disqualification.
Which one?
I'm coming to it.
Now what next?
Yes, my lord, I have given, my lord, case laws at para 44, how the importance of political parties has been recognized by this court, my lord.
Yes.
I'm not reading them. And 45, 46, my lord, the Law Commission, Justice Venkatacharya Commission also recognized the importance of political parties. Lord, one question which your lordship fell, my lord, what is the manifest arbitrariness? It fell from your lordship Chief Justice yesterday, my lord, when my colleagues. My lord, my submission would be, my lord, that 2 or 3 things. My lord. One is, my lord, the distinction we made between a normal bank transfer with the disclosed, I can make donation of any amount by bank transfer. Both are by bank transfers, my lord. Lordship has seen electoral bond is also, my lord, purchased from A through the bank, anonymity, but it is by bank transfer. So you are making a distinction, artificial distinction between a honest contributor who is making disclosure to all of all its funding to the political party, to the shareholders, and to the public at large. Because I have missed out one provision, my lord, I'll show to you, lordship. Conduct of election rules, form 24A. Everything beyond 20,000 is to be disclosed as per the rules. So an artificial distinction is being made between a bank transfer by an honest corporator who wants to say that, yes, I have made this contribution, and to another, my lord, who wants an anonymity. And there is no intelligible difference here between these 2 transfers. Both are bank transfers. Earlier one is with transparency, and second one with opaqueness. Secondly, my lord, as I said, lord, this, how does it work, this electoral bond? For example, my lord, a KYC compliant company purchases electoral bond worth 100 crores. It doesn't want to give. Another person wants to give money to a ex-political party, my lord. It doesn't want to show. It has cash component, my lord. What is going on, my lord? I have talked to certain, my lord, chartered accountants. There is a premium attached to it, my lord. I can buy 100 crores by giving 125 crores, my lord, of cash.
You just said that.
That's what your lordship said. And lordship would find out from any chartered accountant doing this, my lord, and that is a very accepted that 20 to 25% premium is charged by giving cash. So person who is purchasing the electoral bond is getting 100 crores, is getting 100% exemption. Another person who wants to pay to another political company, he paid cash and it reaches the political party, my lord. This is how, my lord, this electoral bond is now functioning, the thousands of crores.
So if, say, a contribution has to be made of 500 crores to a political party,
My lord.
technically you can find 500 people who will each make a contribution of 1 crore,
Yes.
who will each purchase an electoral bond of 1 crore,
Yes, my lord.
right? Each of those persons gets an exemption of 1 crore,
My lord.
a deduction of that 1 crore
Yes.
because you've
He
contributed
gets
to
the deduction of 1 crore.
for
He gets
purchasing.
cash for that.
the political party, it's exempt,
Yes.
but the person who is aggregating
Yes.
and actually contributing 500 crores,
Yes.
all that they have to do is to trade on the electoral bond, pay cash.
That's right. So he's ultimately paying cash, my lord. And that's why I said this is almost a cash available with hundreds of crores rupees available to a person, my lord, who wants to pay cash. This is the manifest arbitrariness in the entire scheme, my lord.
So the actual contributory
Yes.
is not necessarily the person who is
No,
purchasing
not
the electoral
necessarily.
bond in through official
No.
banking channels at all.
So I want to pay and avoid ED, my lord. I want to pay a government which is opposite to central government. Let me put it that way, my lord. To a government in state. I don't want to show to the government, my lord, I have paid. So because the government would know, my lord, to whom it has been paid. Mr. Bhushan has shown to your lordship through, my lord, the State Bank of India route. You don't want to say, my lord, who has paid. I want to keep an anonymity. I paid in through, purchase it and then pay it. Because those bonds, my lord, bonds are there on record, my lord. It does not show, my lord, the number. Infrared number is available, my lord. If your lordship see the format of the bond. Just show that. What is that?
That's
Lord-
fine because these
Lordship
are
has not
bearer
shown the
The
bond.
bearer bond.
It's a bearer bond.
Yes.
It's a bearer bond.
Sorry. The bond.
Only like those Kisan Patras and all.
I'm so sorry.
Kisan Vikas
Kisan Vikas Patras.
Kishan Vikas.
Much better.
Page number. We have noted. Lordship would give me a minute, Lord. I'll show the bond.
The Kisan Vikas Patra has numbers. This has no number.
No, it's an
That's the
infrared
distinction.
number. I cannot see with the naked eye. Only, my lord, the infrared person can see.
Some identification.
Yes, there is. I'm going to, my lord, point out that, my lord, we learned
No,
AG and
it's a
we
cache.
find this.
Lordship, I see.
Let us see it.
Volume 4, 514.
How did you acquire so many electoral bonds?
It's a currency.
Can I have one?
Can-
I have not seen this.
Yes, we have seen it from the record.
Can we have?
Just
One more
give more. Distribute it so long as it is not of 1 crore, I hope.
Doesn't have a value and date of issue.
It is there in volume 4, page 4514 also, my lord. But this gives a better look. If your lordship Google it, my lord, it says on the infrared, you can see a number here, not by naked eye. It's a number. But then,
Admitted by the ministry.
yes.
It has to be numbered, otherwise how will they, it will be fake bonds.
By an official document which is part of the file.
But my lord, you and I.
So
we
there
cannot
is a
read it
number which can be seen on the infrared.
on the infrared by, my lord, the authorized persons, my lord.
All right, so it is easily available.
515,
It can't be,
it's the same.
can be seen on light, my lord. It's not that child's play. There is a system I'm going to
No, we cannot
explain.
see.
No, but
It's only a picture.
even
There's only a
actual, you
color-
can't see like
color photocopy.
in the,
You won't have that number in infrared, you can't find. What is the specimen?
Specimen.
Specimen is 514, also may page the note also.
Okay,
Volume-
we've seen
Very well, no, this is there, this is much better. Amount we आपने छोड़ रखा है.
All right, anything else, Mr.?
Yes, my lord. No, that's-
I think we better wrap up now.
Just two more minutes, my lord. Lord, internationally, this is, my lord, a very difficult subject, my lord, which has been, there is a study, my lord, I'll just give the page numbers of that on record, by a city, by Council of Europe, which has 45 member countries, 46 member countries, my lord, which is in volume 4, page 6920, which has raised serious concern about enormity of the funding by the corporate houses, my lord. If your lordship kindly see that, my lord. Just 3 or 4 pages of that, lordship may make a note of it.
That's all right.
It starts in volume 4, page 6920.
We look at it, Mr.
Yes, and just give the page numbers of relevant page numbers, my lord.
6920.
6920 it starts, lordship may note, 6928, 6930,
69.
28.
28, 6930, 6934, 6939, and 6941. It has raised a serious concern, my lord, about, and the heading is financing political parties.
Thank you very
I'm
much.
extremely grateful to
Thank
your
you,
lordship,
Mr. Ansaria.
and I must acknowledge, my lord, the indebtedness to my colleagues, my lord, who, Mr. Kalita.
So you've unfolded it very systematically. We really appreciate it.
And
Thank you very
two
much.
interns who have done it, my lord, a great help. They are also here from college student. They have given again chart, my lord. I've
Thank
made them sleepless nights, my lord. Nikita and Salvi, my lord. I'm
Thank
extremely grateful to my lords. My lord, only one thing here. 20 section 29C, lordship has seen, my lord.
Yes, yes.
Required. There is a form 24 capital A, in which you have to give form 24 capital A of the conduct of election rules, in which you have to give the details of the contribution of 20,000 and above. There is a statutory form given, and from where, my lord, we get all these details, and they're uploaded on the website of the Election Commission.
These are uploaded on the website?
Yes, my lord. And we have, my lord, all those uploaded documents from where we made the chart at pages 59 to 63. Lordship, I kindly only note, do 2 pages of my note, my lord. I'm not reading it. My written submissions, my lord, volume 1A.
Pages?
Pages 69 to 63, 59 to 63, where, my lord, the calculations have been made as to the percentage of undisclosed source of funding, which varies from 63%, 65%, 72%, etc. Year-wise given, my lord, and these are all from the website of the Election Commission. This
Yes.
is where the charts have been made by my colleagues, my lord, spending sleepless nights and my employees. I'm extremely grateful to your lordship, my lord.
Yes, Mr. Hegde. Thank you, Mr. Ansaria.
This bonds in these millions.
आइए नंबर आइए नंबर
What is your line of submissions, Mr. Hegde? What is the line of submission?
My lords, most of my submissions have been covered. I most respectfully adopt them, endorse them, and vehemently adopt them. Now, my lords, what I propose to do is to buttress some of the submissions. I won't take very long. Please, my lords. My lords, I appear in IA number 106839 of 2018. The applicant is a shareholder in a public listed company. Like the original petitioner in the Jayantilal Kotecha case, who had 3 shares in Tisco, I have a few shares in a few companies. My lords, he has been a public interest litigant earlier also, my lords. My lords, your lordships was shown the electoral bond. And as your lordships was shown that electoral bond, the figure that came into my mind was of the late lamented Mr. Ram Jethmalani, who really brought political corruption to the fore when he demonstrated to a press conference in 1993 how 1 crore was fitted into a suitcase. My lords, when I spoke to my younger colleagues, they said, oh, yes, we saw it in a Netflix series. Scam, sit down. Today, whether it is a sum of 1 crore, whether it is a sum of 100 crores, all that it requires is just that one piece of paper that your lordships has been presented.
Suitcases are not required. Suitcases are not required. Mr. Chairman.
Suitcase not required. One brief envelope suffices. And that brief envelope is time limited.
15 days.
15 days. My lords, there was a better copy at page 6919 of an actual electoral bond for 1,000 rupees, where even the stamp is issued
6919
of volume 4.
Nine.
19 of volume 4. Lordships will see that there is a date of 23rd of January 2023. And the words, for value received, the bank, which is the State Bank of India, hereby proposes to pay on demand to the eligible payee which is holding this instrument upon surrender of the original instrument in the designated account of the eligible political party with the bank, the sum representing the value of this instrument in accordance with the scheme. On payment of the said amount, the liability of the bank hereunder shall stand fully extinguished. So what has been created is a time-denominated anonymous currency. This is, my lords, the currency of power. And I make this submission simply because long ago it was a British Chancellor of the Exchequer, Lord Thurlow, who said, corporations have neither bodies to be punished nor souls to be condemned. They therefore do as they like. A corporation is a juristic person consisting of various shareholders. And those shareholders who are in management take a decision on behalf of other shareholders or on behalf of the juristic person that they will contribute. They will buy electoral bonds And then they are given a further assurance that their contribution to X political party or Y political party need not be reported to anyone.
Yes.
If my lords then see in actual practice over the past few years what has happened, your lordships have been shown various records derived from political party statements, which have been further analyzed by the ADR. Now, my lords, my client, what he has done is, he has gone to the balance sheets of certain listed public companies. They are not before your lordship, so I am not going to mention any names. Your lordships may treat them as Corporation A, Corporation B, Corporation C. But now, please, if your lordships just turns down towards now page 6916, two or three pages before that, my lords. Now, 6915 is the corporation's statement of profit and loss. Thankfully, my lords, those documents are also highlighted at the relevant portion. Now, here, they do not even put in the profit and loss statement, as they are required to under the law, that they have actually bought election bonds. What is done is the next page. Other expenses. And in other expenses, right at the bottom with a double hash, it includes rent, printing, stationery, security repairs and maintenance expenses, etc. Further, it includes political contributions amounting to 273 and 412 made under 182 of the Companies Act during the year of March 31st, 2020 and 2019. Now, this is not 412 rupees. This is expressed in crores. And how do you know that? You go back, because you have to go not crores, my lords, in. Please stop.
All amounts
All amounts
millions
are
of
in
Indian
millions of Indian rupee except per share data. Right at the top of page
So
6915.
it is 412 million rupees.
Yes, is 41 crores. So similarly, my lords, and since your lordships, one of your lordships has penchant for figures. Yes, my lords.
6914, it's specifically miscellaneous expenses
691.
include donation of rupees 20 crores paid to political parties
Yes, my lord.
through electoral bonds.
वो अलग हैं, वो
हाँ,
budget finance
that
है.
is another corporation, my lords. Each of the corporations there are no fixed standards. Each corporation puts it somewhere or the other. Some include it with rent, stationery, and the rest. My lord, sometimes it's said that the truth in affidavits, what is revealed is interesting, but what is concealed is vital.
That's how the accounting treatment takes place in the corporation. Yes.
Please, my lords. So
That's the
now what?
accounting system. That's the accounting.
What is it which is actually required, my lords?
What is
And,
the
if-
Mr.
if you
Hegde
look-
now, what's the submission?
My lords, the submission is this, that even under the current law, at page 8 of the same volume, Mr. Prashant Bhushan's chart, what is required is that no such contribution shall be made by a company unless a resolution authorizing the making of such contribution is passed at a meeting of the directors, and such resolution shall, subject to the other provisions, be deemed to be justification in law. Each time that there is a purchase of an electoral bond by a company, there has to be a resolution of the board of directors, which is not normally open to the public. They are not, the company maintains minutes books. It is available for inspection. Each of these resolutions, my lords, because these electoral bonds are election specific. It can't be.
No. It's the bonds are sold at certain specific stipulated times in a year. January, April,
No.
October, and then 30 days for the general election.
My lords, it is whenever there is an election
The argument of Mr. Sibal is that it's not election related at all. Because when you purchase the electoral bond in, say, January, there may not be an election on the anvil at that point of time at all.
my lords,
And you have to expend it within 15 days. Otherwise, it ceases to be valid in the sense that the contributions made to the PM's relief fund.
it has to be cashed within 15 days.
Otherwise, it
So
serves its
therefore,
purpose.
the political party can take it into its accounts. As to when the political party uses the money, there is no limit on that.
That is what Mr. Sibal's argument, that it can be used for any purpose.
Any purpose at
It
all.
can be used for any purpose. You create an office, a huge political party office. You have residences there for the party leaders. That is sanctioned, and it can be
Therefore, he
done
said
at
that
any point of time.
He said that the term electoral bond is a misnomer.
You can purchase an aircraft or a yacht.
Yes. But the point here is, my lords, this tranche, each tranche of issue of electoral bonds is normally linked, subject to correction, my lords. So your lordships can clarify it with the declaration of elections.
It's not available throughout the year. There are specific times.
Specific times. Those times are often matched.
No. The specific months in a year, I think there are four months,
Quarters.
4 quarters.
It also happens, my lords, that almost every quarter there is an election.
No, it's not necessarily.
And not a state or a...
No, it may be a bipole or something, but not every general election doesn't happen.
Not a general
Four
election,
times
not
in
a
year.
general election, not a general election. But every few months, there is a series of elections. And around that time,
Mr. Sibal is nodding in no, and his experience is greater than yours, at least in that.
that I concede. That I concede. My lords, my respectful point is this, that even with the changes in law, there are compliances required, and those compliances can be further enhanced by what your lordships, the Chief Justice referred to, as far as the Election Commission is concerned. There is the Election Commission notification under 324 with regard to electoral trusts. I would, Mr. Hansaria said that it was not on the website. Thanks to Mr. Prasanna here, I could get it retrieved. If your lordships kindly sees what the election in trust notification itself said.
Just one thing.
Please, Mali.
We take it, all of you, the way you've argued, is the relief you're seeking is quashment of the scheme itself, complete scheme.
Yes, my lords,
Not any part of the scheme. Not any portions of the scheme. Or
No,
you are
the-
seeking is erasing of the scheme with regard to anonymity.
my
And the
lords,
challenge to the validity of the amendments to the law.
it is a challenge
Yes,
to the validity
we have
of the
not-
amendments.
none
I
of
am
you
not.
have Till now been very specific on that. You have broadly argued, but on the question of relief or the prayer you're seeking, what do you?
My lords, I am an intervener. I can't,
You're
I
right.
can't.
You're right. You're
go
right.
ahead.
It's a wrong question to you.
Yes, Malad.
We are seeking that the entire scheme be set aside as arbitrary.
Okay.
And the
One of the
amendments. will be-
elements of arbitrariness is obscurity. That's one of the elements. There are other.
We're not
elements of
asking,
argument.
we're not asking, we just,
Since your lordships put it like that, one of the elements is that, but it's much broader than that, which is what we want.
As an intervener, all that I can point out is
You're supporting the petition.
I support the petitioner, and I'm making a further case that even under the law as it currently stands, your lordships can impose further directions which would possibly reduce the opacity.
Thank you, Mr. Hegde. Thank you.
Would your lordships kindly allow me to place that one election commission document?
324.
Yes,
Please, my lords, under
we
324.
are uploading it. All right.
Yes, my lords, it has been uploaded.
Let's see that.
My lords. This was with regard to electoral trusts. It has been, Prasanna will have. It's out here. As per Rule 17C(a) of the Income Tax Rules, the electoral trusts can receive voluntary contribution from any company or individual for funding of political parties. Under the existing law, for transparency of funding, political parties are required to submit their contribution reports in excess of 20,000 from any person. However, there is no such transparency requirement either regarding source of funding or dispersal of funds to political parties through electoral trusts. Therefore, there is a legal vacuum in respect of disclosure of contribution reports by electoral trusts. In exercise of the plenary powers vested in it by virtue of Article 324 and all other powers enabling in this behalf, the Commission hereby issues the following instructions. Electoral trusts are required to submit an annual report of contributions to the Commission before the due date of filing of the income tax return. The report shall be in the enclosed format. The report shall contain details of contributions received from any person or entity, details of all donations given to political parties in a financial year as per the format, and the format specifies the period and the specificity. The annual report shall be verified, signed by the person authorized, and a copy of the. And if your lordships was speaking of the Satya Electoral Trust ballots, that the list of approved trusts was there. And then, my lords, the abstract of donations, details of the contributions, and Part C, name of the political party, PAN, amount distributed, date, and mode. So it's not as if, even under the existing law, the opacity cannot be reduced. I'm grateful.
Thank you, Mr. Hegde. Yes.
So comment is there, bro, page 7305, volume 4.
Volume 4, page 7305. Thank you.
It's my learned commission.
Maybe we'll put that. Go.
My lords, I appear on behalf of Dalit Panthers Party, my lords. My written submissions are at page 182 of volume 1. What you may kindly have it. Page 182 of volume 1. My IA number is 156371 of 22. 156371 of 22 minutes. $182 minutes.
Yes.
My lords, my submission is threefold. My lords, the first submission is, my lords, we represent a political party, which, my lords, in fact, the political party for a change is on the side of the petitioners, challenging the scheme, the electoral scheme or the secret bond, as we call it from our side. Now, my lords, the issue here is, as a political party which espouses the cause of Dalits and other marginalized people, my lords, this scheme is in such a way it's structured that it has a desperate and a more severe effect on us than other political parties. So that way, my lords, there is a very hostile discrimination as far as our parties are concerned, which expose the cause of these marginalized sections for two reasons. And this court has held, my lord, this is what precisely has to be avoided in any scheme or in any law.
Yes.
What is the first point is, if your lordship see, my lords, clause 3.3 of the scheme, if I may call it as clause 3.3 or rule 3.3 of the scheme, there is a cap of 1% of the electorate. It says, my lords, only the political parties registered under section 29A of the Representation of People Act and secured not less than 1% of the votes polled in the last general election to the House of the People or the Legislative Assembly, as the case may be, shall be eligible to receive the bond. My lords, the point here is, when you make a discrimination between 1% and the other 99%, there is absolutely no rational nexus. Because
a political party should have polled at least 1% of the votes in the election. Tomorrow you may have a 2% party and claim donation.
Well, this is our case. There is a barrier to entry. And nascent political parties, my lords, in a free and fair election, the receipt of political donations cannot be cut. My lords, for example, I start a political party.
You can receive donations, but you can't have electoral bonds coming.
My lord,
And the exemption.
that's precisely the, my lord, that is where I stand at a disadvantages. When people don't come out, my lords, to give monies to political parties on the basis of their ideology, people will definitely not come to me, my lords, on the basis of my ideology, because they want to be anonymous. The very purpose of what the state says today is anonymity is given for the purpose of protecting the people who give these bonds. And when that anonymity is taken away, my lords, my point is that it affects me directly. That same anonymity would apply to me.
Because, even other political parties, it's not that, only a political party like yours espouses the cause of the marginalized section.
Not really.
There would be mainstream political parties which equally espouse the cause of the marginalized group because they depend upon them as their constituents.
My lords, we are next. The point is, my lords, that where anonymity is given to all political parties, I should be given the same anonymity in the sense that I am also a political party registered under the Representation of People Act. Why not 5%? Why not 10%? There is absolutely no empirical data to suggest why you have protected under 1%. The whole point is, my lords, when anonymity is given to all political parties under a statutory enactment.
But then you also have threshold requirements for allotment of an election symbol.
It should be supported by data, my lords. There's absolutely no data. For example, it's 0.99%.
That you made your point. What's the next point now?
That's one point. My lords, the second issue, my lords, is that if your lordship may kindly see the issuing at Rule 3.6, my lords. Rule 3.6. The bond shall be issued to the buyer on a refundable basis.
There's no Rule 3.6. I know para 3.6.
My lords, it's sorry, my lords, 8.2, my lords. I'm sorry. Yes, no, it is 6.6, my lords. It's 6.6.
No, there is no 6.6. You may be referring to 7.6.
It is 7.6.
Volume
yes,
4, page 119.
Yes, my lord. 7.6. The bond shall be issued to the buyer on a non-refundable basis. These are irrevocable bonds. Right. So even by lords, even by mistake, the whole point is read with 10. 10 talks about issuing officers and commission payable. No commission, brokerage or any other charges for issue of the bond shall be payable by the buyer against purchaser of the bond. Now this is taxpayers' money. For example, my lords, if myself or anybody else here wants to buy even a demand draft or a promise or anything else, my lords, there is a charge which is borne by the customer. Here, the customer bears the charges of a note which is being given actually free of cost.
Not
So,
the
my
best
lords,
point,
these
you know.
are
I don't think we need to labor on these points.
these are all, my lords, things which have been tightened
These
to
lie
ensure
in the
to
realm of
facilitate.
policy. These lie in the realm of policy. These are not the best points. I mean, let's
My lords,
not.
your lordship may kindly see, my
We are
lords.
missing the wood for the trees
My
by
lords, if your
focusing.
lordship may kindly see at page 1115, my lords, volume 4.
Substantive arguments have been made.
1115, my lords, your
Let's
lordship
not
may kindly
dilute the
see.
impact of those arguments by going into these.
Well, 1113, my lords, your lordship may kindly see 1113. 1113 for disparate impact. 1113, volume 4. My lords, here, your lordship, under 182, it is the corporate boards which take a decision. And as well as we are concerned, my lords, the empirical data suggests that we control only 3% of the boards in India. That is in respect of 1,000 top companies which are registered in the stock exchange, Bombay Stock Exchange, as well as the National Stock Exchange, where the market capitalization is 1/4. The Dalits and the other marginalized have only 3%.
We are not belittling your grievance. But your grievance is a wider systemic grievance, which is not particularly related to electoral bond.
My lords,
So your grievance really has to be in the form of another petition, which challenges broader aspects of our election law, which have a disparate impact on parties espousing the cause of the marginalized. But by really conflating that grievance with the challenge to the electoral bond, we are really losing sight of the specific challenge in relation to the electoral bonds. You may want to come forth with a petition, a broader petition challenging those provisions of the election law, which may have possibly a disparate impact on parties, say, espousing the cause of the Bahujan parties. We're not at all belittling that, but we're just trying to say that let's not lose the focus of this challenge.
This aggravates the inequalities, my lords. My point is,
All right.
schemes after schemes like this. My lords, today, my lords, my position is, if I am a nascent party.
We don't want to say in this petition, assuming that the others are right, that you have not made out your cause, because that may lead to your cause in that sense being impacted by us ruling on this in a petition where, you know, we don't have the sufficient data.
Then your lordship may kindly
This
see.
overview of our election law. So you are raising a point relating to the marginalized groups, but please keep your powder dry for a substantive challenge in a separate petition. That's what we are trying to just sort of, without advising you, but you know,
I follow.
you don't want to lose the impact of what you are saying in a more specific challenge. This is a very niche challenge in that sense. Very important challenge, but a niche challenge.
Then my ground on 19-1A, my lords, is slightly different. If your lordship may kindly look at my notes, my lords, my 19-1A challenge is that at page 180, at page 187, my lords, that the right to know rival political parties' funding sources is also a part of a political party's right here. But one is for the right of one is for the voter to know, because one is for the voter to know as to who is funding whom, as a right of information.
Party, the Republican Party, are there?
Who bankrolls the rival parties? Well, the position here is, your lordship may kindly see, visualize the position that our parties are in at this stage. Now, bigger parties, because of the money and power play methods, become bigger and bigger. We become smaller and smaller. There are barriers at the entry.
That's not an issue here.
My lords, that's precisely, my lords. Therefore, at least on 19-1A.
Totally going away from the main issue.
My lords, on 19-1A, my lords, in which case, my lords, I'm not pressing that point, at least on 19-1A, the political parties' rights to know rival political parties' funding is.
So, you know, the problem is that you are an intervener. You have not filed a substantive petition. Therefore, we can't strike it down on the ground which you are asserting. You can only support the cause of the petitioners in the main petition.
This is apart from, my lords.
So therefore, you know, you may want to perhaps reassess your position, come to the court or an appropriate high court and challenge specific provisions of the law, election law, which according to you have a disparate impact on the parties which are representing the Bahujan causes. I mean, we're not at all saying that you're not right on your broader grievance, that will have to be examined by a constitutional court. But you may want to perhaps frame it very differently. Why get into it here as an intervener without adequate data, without adequate challenges to other provisions of the law?
Well, it's
the
apart from,
thing.
well, it's in which case, well, that's the other point on 1918.
We will not say anything which will affect your cause. Please rest assured. But we are also trying to tell you that perhaps
Your Lordship may kindly, then Lordship may kindly say that these will leave another day for this cause to be agitated, my Lord. It's not that your Lordship has heard
You're an
it.
intervener.
you are an
No, my Lords, the
intervener.
point is, my
You
Lords,
can never affect your rights.
no, my Lords, the point is, at least then, my Lords, under 19(1)(a), my Lords, I should at least know the critiques of these parties, as far as who is bankrolling, that right to information about political parties being funded.
That Mr. Bhushan argued, Mr. Sibil argued, everybody has argued that. That is no difficulty. Now that has been argued. That point you join with the others.
Yes, apart from, my Lords, adopting all this one, my Lord, the thing is, just one paragraph of the
I
judgment.
think we'll now conclude
My
your
Lords, only one paragraph of the judgment, my Lords, and then I'll leave it to your Lord.
one paragraph of the
My Lords, page 1804, my Lords.
one para of what are you reading?
My Lord, 4204 of Kanwarlal Gupta, my Lord, Justice Bhagwati speaking, as far as these parties regarding elections and the expenditure and what are the other parties' role. Just 10 lines on that.
Kanwarlal has been cited yesterday.
This one paragraph have not been said. 10 lines, 2 minutes,
All
my Lord.
right.
Your
Just
Lord,
tell
may
us.
kindly see, my Lord. This is, my Lords, 1975 3 SCC 696 at page, my Lords, I am reading 4204,
Volume.
volume 4, my Lords.
Volume 5, no? Page?
Volume 5, my Lord, sorry, I'm volume 5.
Go to
Volume 5, my Lords, 4204. It's 10 lines from top. Or 10 lines from bottom, my Lords. Object of the provision, your Lordship got 10 lines from bottom. The object of the provision limiting
expenditure is twofold.
yes, ma'am. It's not my mind, this one. Lordship, may I have a look at it? Sorry, my Lord, extremely sorry. Yes, the object of the
But
provision
I-
limiting the amount far in excess of the limit. The object of the provision limiting the
Already
expenditure
seen
is
it. Yes, you
twofold.
got the point.
That's
That's
precisely
the-
my Lord. So this directly impacts us, my Lords, in a way.
Thank
Therefore,
you.
my Lord, that
Thank you
could be
so much.
considered.
Thank you. Mr. Attention.
What about division of?
Shall I make one short submission?
Mr.
I
Raj
won't
will
be,
now
I won't be making an,
get to the Attorney General's arguments now. Everybody can supplement what they want to say in a small note or something. You have given your note, Mr. Kaliswaram Raj?
yes, I have given it,
Get your
I
note.
have given it, yes.
Yes, Mr. Attention.
We have a division of labor.
Yes.
So on the contours of the scheme, the learned solicitor will advance certain submission. But on larger questions of 19(1)(a), the connection, confidence, etc. That's how we have proposed to divide our labor. So let the solicitor begin on this preliminary submission.
May it please, Your Lordship. My Lord, at the outset, my Lord, as my Lord, the Chief Justice and the bench yesterday I thought Your Lordships are rising. Lord, no, somebody came, so I thought Your Lordships are rising.
Start afresh at 2 o'clock.
I can start at 2, my Lord. It's
Just one thing, you see, there's one larger issue which we are not really examining, that is of election funding, because that's the second issue which arises, but it dovetails into this issue is with regard to the corporate funding. And whether it should be open, transparent, or whether it should be Other issue which arises is they have referred to the kickbacks and the bribes and other things, or quid pro quo. Now, there can be various terms used for that. We like the election commission if they are aware of the total financing which is required for each general election or for the state elections. On an average, state elections will be an average, an amount which is collected and used through these bonds. The issue which may come up is because we have this opacity with regard to who's funding, etc. Then how, if there is any quid pro quo, how does anybody establish it?
We have an answer, first of all.
That
I'll answer that, but please do not bear one thing in mind. Please, for the time being, for appreciating my arguments, remove the two expressions repeatedly used, anonymity and opacity. It is a restricted, limited confidentiality which can be, my lord, opened and the veil can be lifted by judicial direction. I'll point that out.
Thanks. We'll resume after lunch. Yes, Mr. Sarkar.
May it please, so with my lord's permission and my lord permission from the learned attorney. Lord, two basic, my lord, facts I may, my lord, highlight for your lordship's consideration. Lord, first of all, lord, this use of black money in elections and politics in general, elections in particular, every country is grappling with this problem, and country-specific issues are being dealt with by every country depending upon, my lord, the circumstances existing.
Yes.
Lord, India is also grappling with this problem. And as your lordships have seen, Bombay High Court took note, my lord, in late 60s, but the real efforts started by every government of the day, whether it is this government, that government is perpetual, my lord. Every government did its bit to ensure that there is some methodology adopted which eradicates the power of black money or unclean money in the electoral process. But my attempt would be to show a little history on that, my lords.
Yes.
Lord, having tried several attempts, several mechanisms and modes, the menace of black money, my lord, was not being dealt with as effectively because of the systemic failures. And therefore, the present scheme is a conscious and deliberate attempt to ensure clean money coming into the banking system and the election and political parties functioning. And B, so far as possible to eradicate the menace of use of unclean money, unaccounted money or black money as we say in the elections. We are right now concerned with the use of unclean money in the elections. Your lordships may not take this particular scheme as a standalone case or a standalone attempt in the direction of dealing with the menace of black money. There are several steps taken, one of which is this particular scheme, which is confined to the political governance of this political parties culture. So the first step was digitization. The digitization drive, and I'm going to, my lord, give three figures to your lordships. And as citizens, we will be really proud, my lord, to know, my lord, how our country has fared. Digitization necessarily results into all transactions coming through, passing through the banking channels, official channels, what, my lord, is called the information highway. I cannot hide anything. I leave my traces in the digital footprint somewhere or the other.
What is the term that you use?
Information highway.
Informational highway, my lord, where I cannot hide.
This is an information highway.
Informational highway, my lord. I cannot hide.
That's the phrase used for the internet. The internet is an information
Yes.
highway.
Yeah, yes.
Capable of being
Used, my lord, in a limited sense also. But, my lord, your lordships would recall when, my lord, the digitization drive started, my lord, the government was at times, my lord, being mocked. Okay, what is this? This is a utopian idea. Would a vegetable vendor accept by digitization, by your digital payment? Now, a vegetable vendor sending vegetables, I'm not, my lord, elaborating on that. On a gunny bag, is accepting digitized money, my lord, that is whatever app, my lord, we are using. But the important thing, my lord, as citizens, we should be proud of. And this is a part of this process is our digital payment in India is 7 times more, 7 times that of United States and European Union put together. It is 3 times that of China. Meaning thereby, more money is now available in the official channels, and clean money, I would not, my lord, say, my lord, that the black money or unaccounted cash is completely eradicated. That's, my lord, the ideal thing to do. But we do whatever best we can under the circumstances. So, my lord, the first step was digitization. Second step, my lord, in this direction was the registration of shell companies. My lord, the learned attorney, my lord, has placed on record the official record, and it is in my compilation also at page 65, but your lordships need not go into the details, but 65. Between 2018 to 2021, the government of India identified 238,223 shell companies. Actions are taken and nobody has challenged it.
2 lakh?
238,223 shell companies. Because this is one of the vehicles through which, my lord, the unclean money passes hands. Again, this may not have a direct bearing. I am just, my lord, trying to point out that the scheme which is under consideration of your lordship is not an isolated attempt, but is a part of a series of attempts made, whereby now more clean money is available because of the digitized payment. We have approximately 750 million mobile internet users who, now your lordships are aware, my lord, banking is done through mobile internets. And we are adding one new internet user every 3 seconds.
Yes.
Now, after going through the history, your lordships would find out, my lord, I'll be able to satisfy your lordships, or attempt to satisfy your lordships, that each and every word used in the scheme is very consciously used, and what they called anonymity or opaqueness is neither anonymity nor opaqueness, but is a confidentiality by design. And why, how, what is the justification, what is the rationale behind it, I'll be able to explain. The legality of the scheme is entirely for your lordships, my lord, to consider and decide with whatever best assistance we can provide. But one thing, my lord, I'll be able to satisfy your lordships that if the element of confidentiality goes from this scheme, the scheme goes, and we are back to 2018 regime, and I am going to show that regime, my lord. And your lordships would like to ask the petitioners what benefit you will get if the country were to go 10 steps backwards. And I have the facts and figures with me. Lord, unfortunately, the petitioner, one of the petitioners, my lord, that is ADR, has placed all its reports on record, except one which is the most crucial. Lord, as a passing remark, my lord, without making an issue out of it. Generally, when you are approaching the court in public interest, you place everything which assists the court. You don't place something on which you wish to argue. Anyway, my lord, my written submissions, volume 2A, page 102. Lord, please see the position we will be back at if this scheme is to be, my lord, interfered with as prayed by the petitioners. This is, my lord, the report prepared by ADR, the petitioner before your lordships, based upon the figures published by the Election Commission of India. And my worry, the worry of the government and the worry of every citizen is that if this scheme goes, we go back to this regime. And what would be the transparency in this regime? What would be the national benefit to this regime? It's for the petitioner to explain. Lord, please see the highlights. Your lordships have, my lord, the title is Analysis of Sources of Funding of National and Regional Parties of India for accounting year 2004-5 to 2014-15, 11 years.
Which page number?
102, volume 2A of my written submissions, my lord. The right-hand side top, just for identification, is ADR.
Yes, you know, volume, we,
2A, my lord.
नंतर आलंय ते. आज सकाळी त्यांनी दिलं.
Volume 2A, my lords.
मिळालं तुला?
My lord Justice Gawai got that? No? My lord Justice Padiwala has got that. Justice Michelle. Yes, I have no. But one thing is very clear. Okay. Lordships made very clear that your lordships are not examining whether there can be a political contribution or not per se. The question is how, whether this scheme is legal or not. That's a wider question, Manoj. That's not arising here. But ADR has also accepted that there is an element of money involved in the contesting elections, running a political party, running several other activities by the political parties, etc. Lord, kindly read all these figures with one caveat in mind, that these are the figures declared by the political parties voluntarily and published by the Election Commission.
102.
Everything may not have been declared. I'll not pitch it higher than this. This is what is declared, and the figures are shocking. Any interference, my lord, in the scheme takes us back to this position. Please see, political parties play a key role in democracies as they contest elections, form governments, formulate policies, and are responsible for providing governance and improve the lot of the common man. Your lordships can skip the rest. Please come to the highlights. Highlights. This is, my lord, again reported money, my lord.
What's the
And-
date of this report? It's
The date is
24/7.
24th of January
17.
2017, but the period is 2004-5 to 2014-15. Different, my lord, formulation in the central government. This would also meet with one of the arguments, my lord, very vehemently raised, that look, the ruling party gets the maximum benefit. That has always been the trend from the beginning. You can't help it. 2004 to 2015, there was a different ruling party in power. Now, please see this. The contribution statement submitted by the political parties declare, your lordships are on the highlights. My Lord Justice Gawai has done. The contribution statement submitted by political parties declaring names and other details of donors who contribute above rupees 20,000 are the only known sources of income of the political parties. The unknown sources are income declared in the IT returns, but without giving source of income for donations below rupees 20,000. Such unknown sources include sale of coupons. This is done by the CPIM, Mr. Farasad's client. Ajivan Sahyog Nidhi, Relief Fund, miscellaneous income, voluntary contributions, contribution for meetings, morchas, etc. The details of donors of such voluntary contributions are not available in public domain. Other known sources of income include sale of immovable properties. Your lordships can skip that. Kindly come, my lord. Next, total income. Your lordship gets that, my lord. Rest is not relevant, my lord, for either of us. Total income of national and regional political parties between financial year 2004-5 and 14-15 is rupees 11,367.34 crores. Total income of political parties from known donors, details of donors as available from contribution reports submitted by parties. They may not have, my lord, submitted all. And black money was in vogue during that period for all political parties. Rupees only 15% of the total income. Now, total income of political parties from unknown sources, income specified in the IT rules whose sources are unknown, rupees 7,832.98 crores, which is 69% of the total income of the parties. Now, please see, my lord, national parties. My lord, the chart your lordships has. The second column of the chart. My lords have the chart. National parties, rupees 6,612 crores, income from unknown sources. My lord, what is this unknown sources? I'll just tell you, lordships. My lord, my lord, before your lordship goes through, my lord, further, my lord, one clarification would be very, very relevant. My lord, may I complete that first, or my lord, just yes. Clarification. My lord, every political party needs clean money also, because they have to show expenditure for the purpose of rallies, this, that, and others. How do they do that? And some other shocking details will come. My lord, I deposit 100 crores as a political party, saying that so many thousand people donated 19,000 rupees to me each. If it is less than 20,000, I'm not supposed to disclose his identity. So the cash which I received, I'm showing as unknown sources income, the donation in the form of individuals who have supposedly given me 19,000. That is, and no record is required under the law, because 19,000, there is no record required. This is the amount, my lord, which is 69%. National parties is 6,612 crores and regional parties 1,220.56 crores. Then income from known sources. Please see, my lord, substantially less.
Mehta, just one question here. This 11,367 crores is as per the income tax returns?
Yes.
So they'll be over and above that.
Over and above. Therefore, my lord, I say that whenever your lordship reads these figures, please bear that caveat.
This figure which is taken out by the ADR is not what they perceive as the actual income.
Cannot.
What is?
In the contribution reports.
in the contribution reports, in the income tax report.
It is what is disclosed by the political parties to the election commission. Therefore, I started with a caveat that your lordships may bear in mind. These are declared figures.
There's one issue. The figures therefore you are showing us over with regard to 69% are those 20,000. Less than 20,000, which has now been reduced to 2,000.
Maybe to some extent, they may have given names also. But
No, they may not,
largely-
they wouldn't have given those names. That 20,000 figure after 2017, I think, has come down to 2,000. That's been reduced to 2,000. So this is a
position of all political parties. Now, your lordships may kindly, my lord, for the time being, ignore the diagram and come to, my lord, the written part. Political parties with maximum income from unknown sources. During the 11 years between 2004-5 and 14-15, 83% of total income of so-and-so amounting to rupees 332.39 CR and 65% of total income of so-and-so amounting to rupees 2,125 crore came from unknown sources. We were grappling with this situation when this scheme was conceived. Among the regional parties, rupees 766.27 crore or 94% of the total income of so-and-so party and 88.06 crore or 86% of the total income of so-and-so party came from unknown sources. Now, your lordships may kindly come to page 105, observations of ADR. 104, I'm sorry, page 104.
Recommendations?
Observations of ADR. Of 104, page 104. There's no page. Of the 51 regional political parties, I'm sorry.
Yes.
Considered for this report, I'm sorry, my lords are writing.
One more question. As the returns filed by the political parties in 29C are all uploaded on the website of the election.
They have taken from them only.
Of the Election Commission of India.
But as per ADR's own stated case, they have analyzed this based upon those reports.
Because the Income Tax Department will not reveal the details.
They can't use. They can't use. This is the Election Commission's website. That's their case also. Of 51 regional political parties considered for this report, 45 parties have not submitted their donation statements to ECI for at least one financial year. The 12 regional political parties which have never filed their contribution report since 2004 and 5 are, I'm not reading the names, I don't wish to make it political, I'm just pointing out this is the problem we were grappling with, which, my lord, eventually led us to examine, evaluate and find out a solution. And income tax returns or audit reports of national and regional parties were obtained by filing RTI applications with the Income Tax Department. The income tax returns of 42 out of 51 regional parties analyzed were unavailable for at least one financial year. The information was either denied by the IT department, the parties had not filed their returns for the financial year, or the department were unable to trace the audit reports. Incomplete information was provided. Where possible, copies of audit reports were procured from the ECI. The income of national parties from unknown sources, please mark, my lord, increased by 313% from rupees 274.13 crore during financial year 4-5 to 1130 crores during financial year 14-15. The income of regional parties from unknown sources increased by 652% from rupees 37 crores during financial year 2004-5 to rupees 281 crore during financial year 2014 and 15. Among all the national and regional parties, please mark this, this is something very, very funny and something very, very alarming and shocking. Amongst all the national and regional parties considered, so-and-so is the only party to consistently declared receiving nil donation above rupees 20,000. They have not received any donation. Everything is below 20,000. Between financial year 2004-5 and 14-15, thus 100% of parties' donations came from unknown sources. The total income of the party increased by 2,057% from rupees 5.19 crore during financial year 4-5 to rupees 111.96 crore during 14-15. And this is as declared within 19,000. Now, please come to page, my Lord, 105. My Lord, the argument that the scheme has benefited the ruling party. My Lord, my respectful assistance to your Lordship is this. More contribution going to the ruling party is the norm. That's the sorry.
Yes, Mr.
Lord, kindly see the third bullet point, detailed report your Lordship would
Why
find.
is it, according to you, why is it the norm that the ruling party is making the substantial part of the donations? What's the reason for it?
I would not be able to hazard a guess, but the figures show that whoever was ruling party, either in the state or in the center, possibly, this is my
Well, no,
assistance.
gives with an expectation, right?
Yes, Lord, I'll just tell your Lordship, my Lord, how the things work. And this is my reply, not government's reply. But
Yes.
This is my assistance to your Lordships. Generally, Lord, every political party has their programs and policies, etc. They have their working style, which are distinct, and all people, my Lord, they have confined their arguments to corporations or companies, but they are individuals, contractors, HUF, because HUF is also now a financing entity, etc. They know the working style. They know their business style. That if this party forms the government, it would be beneficial that we'll be able to be comfortable with them because there is less of red tapeism. Somewhere it is more of a red tapeism, etc., etc. Lord, what is running in the mind of the Lord, this donor, Lord, is not possible. But Lord, by and large, they decide based upon their interest. Obviously, Lord, they are not doing a charity. Let us, my Lord, be not very idealistic the way they would like your Lordships to be, my Lord, while dealing with a very complex problem. Practically, they are also doing their own business and their decisions are business driven, or as we use the expression, it's a market driven. That more powerful the leader, more cadre based the party, more chances of success. I feel that I'll be comfortable while doing my business, less corruption, more corruption. These are the factors based upon which, Lord, they donate. But your Lordships may practically, my Lord, keep one thing in mind. All big donations or big donors, whether individuals or others, trust or companies, etc., they donate to all parties who are relevant to them. The figures differ. And ultimately, I'll be able to show, after showing the history of this, that why black money was used to pay political contribution. Well, this is the bottom line of this scheme. Which the government has sought to address.
So Mehta, what you said can be one reason. The other reason is money circulation by the party themselves,
Money circulation.
by the parties themselves.
The party, my Lord,
Because you don't have to give the details of any donor who is paid less than 20,000 rupees. So any money which is available within the party, it can be circulated. The unaccounted for money is circulated back into the system.
my Lord, in this scheme, it is not possible, but
No.
maybe, my Lord, maybe. But I don't think, my Lord, the party tends to gain by circulating, but
Only thing is because you have to show on table a particular level of expenses whenever you incur expenses, say in a rally or any other expense, certain expenses have to be shown. The second point which you are raising is relevant, obviously, these figures are relevant. The second point is these unaccounted or unaccounted for were in the transactions below the figure of 20,000, not in the higher. Already
Not reported, my lord. I would put it. I can go and give you 5 crores, but party may choose not to report.
That
Yes.
is possible. That is possible. But as far as the higher sums above 20,000 were concerned, they were all reported. They were already with details. Their reporting is with details because we saw some charts given to us. Most of the payments were reported. Above 20,000, payments are to be reported. Otherwise, it will be violation of the law.
The bottom line, no, I'll take your losses further, but the bottom line is this, my lord. What was really found, that what is the reason why a person who contributes to a political party chooses the mode of unclean money as payment mode? And your lordships would, my lord, immediately agree with me if we go by the practicalities of life. My lord, what happens is, my lord, suppose one state is going for an election. There are two parties, but they're multi-party, but by and large, there are two parties which go neck to neck. Suppose I am a contractor, and I'm not a company or anything, I am a contractor and I'm supposed to give my political contribution to party A and party B, or party A or party B, as the case may be. But the fear was, if I give by way of accounted money or by clean money by way of a check, it would be easily identifiable. If I give to party A and party B forms the government, I would be facing victimization and retribution. And vice versa. If I give money to B and party A continues to be in government, then I would be facing retribution or victimization. Therefore, the safest course was to pay by cash so that none of the parties know what I paid to which party. And both parties are happy that I have paid some. So that the payment by cash ensured confidentiality. Both parties would say that one party would be given 100 crores, one party would be given 40 crores, depending upon my assessment of their winnability. But both would not know who is paid what. But sometimes what used to happen is, in my business, I get only clean money or substantial part of the clean money, but practicalities require that I contribute to the political parties. And practicality again requires that I contribute with a degree of confidentiality so that I'm not victimized in future. And therefore, clean money used to be converted into unclean money, white money being converted into black money so that it can be paid according to them anonymously and according to me with confidentiality. And this is disastrous for the economy when white money is converted into black money.
But as the learned Chief Justice yesterday gave an example, quite possible that 100 people may buy bonds at one crore rupees each, and somebody may purchase those 100 crores by paying cash.
I just, my lord, I wanted to answer that question, my lord. My lord, I also examined, my lord, that question. What your lordship's query, my lord, as I have understood is that suppose I have 100 crore in cash. Now your lordships are examining the scheme for the purpose of answering this particular query right now. I'll go into the history thereafter. I have 100 crores. What I will do is, I will give him cash of 10 crores that you deposit this in your account, buy a electoral bond of 10 crores, give it to me. I'll give another 15 crores to my another learned friend, and I will aggregate. Kindly, my lord, see the situation. The moment 10 crore of cash goes in his account, look, there are checks and balances within the income tax department. He will have to face the investigation. My learned friend will have to face the investigation. I will be involving 10 to 15 more persons to buy 10 to 15 electoral bonds. As against that, it's easier for me even today to go with 100 crores to a political party and say, they take this 100 crore in cash. Why should I, Lord, involve 10 people as my accomplice?
No, the advantage is that the political party will get it in white. There's an advantage for the political party because it will get
I
it.
would not risk myself. The reason is this, the moment, my lord, 10 crore cash goes in his account.
Suppose if 100 companies,
Yes,
they purchase it, they are, let us assume all of them are in profit.
yes, my lord.
They purchase for 1 crore. So they will get a double benefit that they will get income tax exemption for the amount that they have paid on.
Correct.
Yeah. And also if they transfer it to an aggregator, they will get cash also for that.
The difficulty is, my lord, the moment he deposits 10 crores in cash, my lord, the income tax department.
No, no, I'm not talking
He's not going to deposit 10 crores in cash. Who will ever deposit 10 crores in cash?
Then I'll show the scheme. It has to be deposited if he has to.
No. The problem with the scheme, Mr. Solicitor, it provides for selective anonymity. It's not completely anonymous. It provides selective anonymity
Confidentiality.
or selective confidentiality. The State Bank of India, it's not confidential with the State Bank of India. One, it's not confidential with the law enforcement agencies. So a large donor would never take the risk of buying the electoral bond for the purpose of tendering it to the political party. All that the large donor has to do is to disaggregate the donation, get people who will purchase electoral bonds with small amounts which will be then purchased through the official banking channels, not through cash. If you have to
Provided they have 10 crores. So I will have to find out 10 people who are having 10 crores and who are ready to risk that. But my lord, I need not tell you a lot.
What will really happen is this. A large donor will never put his or her head on the line by being in the books of account of the State Bank of India of having purchased.
They are doing it.
He won't do it for the opposition party, he'll do it for the ruling party.
There is no.
So,
Please.
Mr. Bhushan, they did not interrupt you.
Please, Mr. Bhushan.
so what would really happen is this, and that this is what the scheme is capable of because it's selective anonymity,
Lord,
selective confidentiality.
My lord, I need not tell your lordships, my lord. A possible or potential abuse may not perhaps be the ground, but let me explain the entire scheme to your lordships. In a given.
Second, Mr. Solicitor, your argument that, look, if you were to strike down this scheme, you will go to a situation which had existed prior.
Can I
That,
come?
I'll just, you can deal with it in your own course. That would not be valid in itself for the reason that we are not precluding the government from coming out with a transparent scheme or a scheme which has a level playing field. The purpose of ensuring that electoral funding relies less and less on the cash component and more on the accountable component. It's of course, it's work in progress. We are completely with you. There's no difficulty. We are completely with you that this is a problem which democratic societies are grappling with. But the point is not that, it's not an all or nothing approach. The problem with the scheme lies is if it doesn't provide a level playing field to political parties, and B, if it suffers from opacity, as the argument for the other side is. This is not to prevent the legislature or the executive from coming out with a scheme which deals with these deficiencies.
Confidentiality goes.
No, it may be that the confidential, we are not saying what it should be. That's no part of our function.
That's not.
That's not a part of our function. But, two very important things. Maybe the earlier scheme failed. Maybe it didn't get you as much of white money into the electoral funding as you would otherwise have liked to do. But look at the safeguards in the scheme, in the earlier provisions. A cap on how much of your net profits you can contribute. One.
I have an answer to that.
Two, a disclosure within your own accounts and therefore to your shareholders that this is the political party to whom we are contributing. What we are now doing is that in the effort to bring in white money into the electoral process,
Yes.
essentially we are providing for a complete an information hole.
Can I, my lord, respond?
That is the problem. The question,
But I believe, my lord-
the motive may be perfectly laudable, no question about it. Question is whether you have adopted means which are proportional,
Lord,
or whether, or do the means meet the test of
my lord,
Article
take
14?
it. I take it, my lords.
Yes.
So that I am not discouraged, that your lordships are just putting to me what is their contention.
Obviously, that's why I am hearing you. Our views are never final until the last word in the case.
I know that, my lord, at 3 o'clock, my lord, it's too much of a seriousness, my lord. I wanted to break
Yes.
that seriousness.
Mr. Solicitor, our word is the last word, actually only when the judgment comes.
Judgment is delivered. I know, my lord, I know.
In fact, even after arguments conclude, we are all involved in parleys and discussions
Absolutely.
between
Your
ourselves.
lordships,
Formally,
confer, this was just, my lord, to break, my lord, that aura of
clear
seriousness.
And us putting questions is getting.
To get the answers. I bow.
Yes.
I understand, my lord. I have appeared before your lordship on the hundreds of times, my lord. I'm just on the lighter side. I wanted to, my lord. So, my lord, your lordship's, my lord, concern is right. But when I explain the scheme, your lordships would find that anything else other than keeping it confidential, my lord, will not be able to address the problem of victimization. And victimization incentivizes payment by cash.
So here,
And here,
just one caveat over here.
yes,
Victimization and retribution is normally by the party in power,
yes, 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 my lord.
not by the party which is in opposition.
My lord, the opposition may come
But
back in
just-
power
just-
after a month. My lord, I'll just, my lord.
So, but the figures which you are saying, that the maximum donations which are on paper, which are accounted for, are to the party in power and not to the party in opposition, may not therefore be logically flowing from that argument.
No, I am pointing this out, my lord, only to satisfy your lordships, my lord, their argument that because of this scheme, maximum money goes to ruling party. I am just trying to, my lord, show to your lordship,
Just
there
one
is
more
a
question.
trend,
Just one
whether
more-
it is this scheme or prior to that.
Just one more question and therefore thereafter the field is up to you. The other issue is, which is because of selective confidentiality. Now what happens is when the selective confidentiality as far as donations to the opposition party is concerned, there are ways and means to get that information. And it's easier for the party in power to get that information.
It's not.
Let's put it very frankly.
Well,
You've been very
let-
frank
very
on the
frank-
first aspect. Let's be also very frank on the second aspect.
My lord,
Now what is the fear is, because of this selective confidentiality, the opposition parties do not know who are your donors, but donors to the opposition party can be ascertained, at least by the investigating agencies.
Lord, I'll just tell your lordship, Lord,
So
nobody
they are
has-
put at a disadvantage to question you on your donations, whereas their donations get questioned.
I'll just, Lord, answer that question. You will have to trust, Lord, we will have to trust at some stage someone as the final fiduciary position capacity, Lord, authority. Second, Lord, nobody has so far taken your lordships through the scheme and how the scheme operates. That's what, my Lord, I intend to do. Lord, possibly this may not be 100% foolproof scheme. Lord, there may be out of 100, 5 people which my Lord, the Chief Justice, my Lord, indicated. They might misuse it. But suppose I am a genuine person who wants to contribute without any retribution. Lord, I'll just give an example. I don't wish to give any example of a live election, my Lord, but imagine a state which is where election process is going on. Party A is in power, party B is likely to be in power, and both are neck to neck. As a contractor, my lord, I would like to, my lord, contribute to both the parties because I know that there is 49% possibility of party B coming into power. And therefore, I will have to be my lord, contributing to them. I am on practical lines without being idealistic, etc. I'll come on transparency, informational privacy, etc. But let us take it on a practical plane. Either way, my lord, I will be incentivized to give cash because I do not know whether B will form the government after a month. And I do not know whether A will continue to be in the government after the month. Either of the way, my victimization and retribution will continue. So the only incentive is to pay by cash. Nobody knows what I paid. As against that, I will explain in the scheme that nobody can come to know, including the central government. Including the central government, I'll be able to show from the scheme. But every provision is made with some intention, some rationale, some justification, and some purpose to prevent some malpractice in mind.
But retribution is not avoided by this scheme. I'll tell you the simple reason for it. Under the Companies Act as now modified, a company is not required to disclose to which political party it has contributed,
Correct.
but it has to disclose how much it has contributed
Correct.
totally.
Correct.
So companies, say a large public limited company says, I have contributed 400 crores this financial year, right? Now, the party, including a party in power, whether in the state or in the center, knows how much has come to it in terms of electoral bonds from that particular company?
It can never know. Therefore, allow me.
No, the party, of course it knows.
If the donor discloses
Party
identity,
ABC, Party ABC knows how much has come from this company into its coffers. You also know from the company's balance sheet how much it has contributed in a macro sense. So that balance sheet no longer discloses to whom it has been
unless, my lord,
contributed. That mismatch is sufficient to know as to how much money has gone to the party in power. So it's not that the possibility of retribution is averted by this scheme.
so far as possible. But, my lord, after I explain the scheme to your lordships, my lord, your lordships perhaps may have a rethink on this, my lord, apprehension. Because otherwise, my lord, I asked them, what is a better solution? Reverting back to the earlier incentivized black contribution scheme? No, that's again a question. Out of 100, my lord, everybody doesn't pay by 400 crores. Lord, they pay
That's
5
Mr. Sharma. What is the better solution is for Mr. Sharma to answer.
Pardon, sir?
That's for Mr. Sharma to answer. Even if we have some answers or questions, we will not answer that because we are restrained by judicial review.
Lord, so I was on page 105.
105?
5. My lord, just to show that between 2004-5 to 2014-15, it's not because of the scheme, but because of the trend, because of the consistent practice of the contributors that, my lord, so-and-so party got, my lord, maximum, then the second, then the third. My lord, they know who is going to be in power. My lord, they are better judges, my lord, than of the electoral process. Then, my lord, the common man or those who contribute, but they know that where to invest their money. And I'm using that expression, my lord, which I should not have used. Now, please come to page 113. Page 113, income of political parties from unknown, known, and other sources. But here there was a complete anonymity or opaqueness or confidentiality, whatever name we may use, because once I pay in cash, I have no difficulty at all. Nobody can find out what money I have paid to Congress, what money I have paid to BJP or TMC, anyone. Complete, my lord, immunity from retribution or victimization. Now see, my lord, please see, unknown sources. The first party is 2,000 some crores. Second party, 3,000 some crores. Please see, my lord, the last, for which Mr. Farasat appeared, 471 crores. They say that we don't buy electoral bond. They better start buying electoral bond. And I'll point out, my lord, I don't wish to go into it. What is the source of their funding? Then, my lord, known sources. Please see, my lord, for the last party, my lord, 15.04. Known sources, 15.04. They are running a government. And other known sources, 406 crore. And what is other known sources, my lord? Please, my lord, kindly. We have BJP has 228 crores. And they have done. See the fourth column, other known sources. What happens when they don't buy the electoral bond? I'm sorry, my last political party, other known source, your lordship gets. But this is 406 crores. I have their balance sheets. Other known source means membership fees. And membership fees is more than double than, my lord, both the national parties, BJP and Congress. They have kind of a bucket collection. There are several things, my lord, which the best thing to do is, my lord, to ensure that they get electoral bonds, my lord. Then only, my lord, this kind of a situation, my lord. Please see the chart below. Regional parties, my lord. Now, the interesting figure. I will not take your lordships to examples of each of the parties, but see the first party. Unknown source, 766.27 crores out of total, please see, 819 crores. Last column is total. So out of 800 crores, 766 crores is unknown sources. Maybe out of 100, what your lordship say, in 2 cases, it may be true. But otherwise, this is the position.
In the other known sources, when they submit to the ECI, they give the names of the persons? No.
Yes, I think so, yes.
They give the names of the
They
persons?
give the names. 1,50,000.
For CPM, I'm not speaking
No, no.
about CPM, I'm just saying that it's a sort of.
Let CPM defend itself. You need not bother. CPM is very much here.
Please, please.
You can rest assured, he will competently defend it.
Interestingly.
I didn't name the party, my lord. History. Name any political party, my lord, that well, I didn't want to politicize it, but it was necessary for me to give these figures to your lordships. That if confidentiality
The Malays is agnostic to political parties,
Yes.
whichever side of the spectrum you are.
Yes,
The Malays affects the entire spectrum. So we're not here saying that a particular political party is holier than the other. I mean, we have a problem.
That's a problem which we are grappling with.
And this figure which you have said, we'll again not say more than that, is 2004-5 to 2014-15.
That's all. But I also didn't say anything. I only highlighted the period that this was, even prior, this was the trend.
Your chart was not lost to us.
I'm grateful, man. And the chart which Mr. Bhushan's client should have placed. It is his chart. He has placed all the charts except this chart.
But Mr. Solicitor, therefore that really, for us, would really still beg the question, in the sense that for us, it's not whether, the ruling political party in power presently is going to be the beneficiary of that or not. We are testing a question of constitutionality. And we take your point that, well, this is part of our political system. Whoever is in power gets the large share of the pie insofar as electoral contributions are concerned.
Yes.
So we have to deal with this uninfluenced by all this, by the vicissitudes of the change in
I'm great.
political
I'm
fortune.
great. Because that keeps on changing. And party which is in power in the center, may be in
May or may not
opposition
be
in
the
state. The state may be completely different party, like my lord, West Bengal, it's neither in center. So this, my lord, in our federal structure, that keeps on changing. So your lordships are necessarily confined to, my lord, whether this scheme is constitutionally, my lord, valid and can appeal to your lordship. Now, please come to, my lord, page 6. What are the earlier efforts made? And, my lord, some of the discussion in parliament,
Page 6.
page 6 of my written submissions 2A, the same file, same document, my lord. Because I must say, my lord, to the credit of all our leaders across political lines, that everyone has tried their best. Lord, sometimes the problem is this, my lord, and I was, Lord, really told about this problem. In political parties also, there are divergence of views, whether to support this scheme or not to support this scheme. And the reason is genuine, practical, but a little humorous. What happens is, I am a leader, I am a local leader in a state, or third, fourth ranked leader at the national level. I get 30 crore by way of political contribution to my party. I would deposit only 25 crores in the party. In case of electoral bond, every rupee goes to the account of the political party. If I have to accept it, I have to accept only through electoral bond. That, unexpected benefit will not be available to me. So, there is a debate even amongst other political parties that this scheme works well. That this element is at least eliminated. Now, please see, my lord, what are the efforts which were made, and then I will link it to the speech of the then Honorable Finance Minister when this scheme was introduced. That every effort was made, every permutation, combination, this can be the solution, that can be the solution, everything was tried by the nation. And we reached the situation which I have shown at page 102 onwards. And now, with that problem, the nation, as a nation, I'm not going one party or other ruling here or ruling there. As a nation, we started thinking, and in the parliament, this scheme was not presented, and why it was not debated, how it was debated, I'll point this. Lord, please come to page 6. The position in India. Lord, I have before that given the position of other states. I'm not reading it. It's for your lordship's assistance. I'm sorry, page 7, page 6. 1956, section 293 read with 293A of the Companies Act allowed corporate donations to political parties as long as memorandum of association of the company permitted the same. My lord, your lordships have seen 1957 judgment, and therefore I am not reading it. Lord, it's a judgment reported in 58, but it's a 57 judgment. But at page 7, my learned friend, my lord, missed the last part. I need not, my lord, remind your lordships are aware of it. But ultimately, my lord, Justice Chagla says this after, my lord, that discussion, which I have quoted, my lord, on the first column of page 7. But it is not for us to legislate, as my lord, the Chief Justice said, nor is it for us to lay down the policy. But having had this case before us and our attention having been drawn to the possible evils attendant upon powers exercised by the companies, we thought it our duty to draw the attention of Parliament to the necessity of remedial measures being immediately undertaken to curb and control the evil. Now, Lord, possibly as a result of this judgment or otherwise, Lord, we do not know what happened, what were the circumstances in 69. But Lord, there is one article, my lord, where I could find something. Lord, before I take your lordships to this 69, my lord, the theory is that in 69, there was a party called Swatantra Party floated by
Pilu Modi.
No, that was by Rajaji.
Rajaji and Pilu Modi. Rajaji was really the...
Rajgopalachari, my lord, was the founder of that party, and that party was gaining momentum. This is, my lord, a theory. And the government of the day wanted contributions to that party, which was gaining momentum, to stop. And therefore, they prohibited any contribution by the companies. Please, my lord, see 69. following the recommendation of Santhanam Committee, the government introduced an amendment which prohibited any contribution by a company to any political party or for any political purpose to any individual or body. Lord, your lordships can mark this. Santhanam Committee report, I'm not going to read it, is in volume 4. Volume 4. Now, I'll just give the page number, but your lordship need not read that. But as a part of that committee's report, it was followed by the government and the contribution was.
What is the page in volume 4?
I'm just. Page 8103, my lord. Serial number?
We just to make a, yes.
Yes. Now note. Note is interesting, my lord. Therefore, I am tempted to place it. Since corporate funding was illegal, the corporates and politicians created several backdoor routes of channeling the money into the Congress party. I'm sorry, I don't mention names of party. Facilitated by large sums of cash holding with businesses. A commentator has called this practice briefcase politics. My Lord Justice Gawai, my Lord, used this expression, briefcase politics, referring to a prevalent practice of pricing government permits at number of briefcases of cash that can be supplied. In exchange of doling out benefits to corporates, the party collected large amounts of cash and illicit money, while at the same time depriving opposition parties of legally collecting funds from the corporates. Thus, corporate donations continued despite bans, they just became underground. It is devised a new method of legally channeling corporate money into so-and-so coffers by placing corporate advertisements in party journals. Magazines used to be published, souvenirs used to be published. These corporate advertisements were an indirect way of funding the party without violating the law. My Lord, I have given which article from which I have taken this. Then, my Lord, in 1979, the Income Tax Act was amended to exempt the income of political parties from taxation by way of Section 13A. Subject
Before 79, the income tax parties were not exempt, political parties were not exempt?
I think so, my Lord, subject to being corrected, my Lord. That's my research shows, my Lord, it, not to my knowledge.
Check from Mr. Palkiola's book or.
I'll check up, my Lord.
Because when you use the word amended to exempt, maybe a loose.
Was amended. Yeah, my Lord, must be amendment means there must be pre-existing exemption. My Lord, I'll answer this, my Lord, tomorrow. Then 85. My Lord, 85, the then government, my Lord, took a bold step. We see corporate funding was reintroduced by the government by making necessary amendments in Section 293A of the Companies Act. All companies except government companies were allowed to contribute to political parties or to any person for political purposes, subject to approval of the board of directors and disclosure in the profit and loss statement. Here also, the board of directors decide. That's the regime continuing till the scheme came. These donations were restricted to 5% of companies' average net profits of previous 3 years. Lord, now please, my Lord, see the debate in Parliament when this was introduced, my Lord. That would really assist your Lordships, my Lord. That is in my volume, my Lord. I have, my Lord, circulated a second volume. I'm not going to read the whole, but, my Lord, I have placed the entire debate, my Lord. It's at page. Page 41.
Volume 2.
Volume 2B. No. 2A of documents, if you can. It's called, my Lord, compilation of documents.
Compilation of documents.
ये कहाँ है यार?
It's on the screen.
Yeah, yes, ma'am. Yeah, yes, ma'am. This is the one, my Lord. Your Lordships are on the right page.
नहीं, पर हमारे let's get it down.
Of documents or 2A?
2A, my lord, compilation 2A.
2A is your written submissions actually.
No, there is compilation 2A, my lord. Compilation 2A, my lord, that's how it is.
What is it, does it begin with?
Lord, it is compilation on behalf of Solicitor General of India, my lord. That's the title.
That's
Because-
volume 2, not
Because
2A.
the-
Final compilation of Union of India.
Yes,
Compilation two, volume two, final compilation, no.
no, 2A doc, that's the,
Airdrop कर देना.
yes, my lords. No, additionally. I'm thankful to my learned.
No. I wish you had told us,
No, no,
but
yeah.
it doesn't matter. Indeed.
We had requested them more than a week earlier, 10 days earlier. You give us whatever documents we'll upload.
It's okay.
But anyway,
It's all right. It's too big a matter to start objecting on these technicalities. Huh?
Kindly see, my lord, page 41, your lordships have on this document. Lord, we'll sit with the court master and, my lord, give the appropriate nomenclature or the title to this, my lord, compilation.
On the screen, yeah.
It is, my lord, essentially a debate of parliament. It's not a document, my lord, in that sense of pleadings or something.
This is
Lord,
the
this is,
1985
Yes.
Companies Amendment.
yes, Companies Amendment Act Bill 1985. The Minister of Chemicals and Fertilizers and Industry and Company Affairs. My lord, please read.
Just give us the page reference. This will be called compilation volume.
My lord, whatever your lordship says, we will accordingly, my lord.
Okay. क्या होगा ये?
That's what I'm saying, that whatever the court.
Said 41 earlier.
41 is the.
2B.
41 it starts.
The honorable members will recall, well, your lordships have, my lord, all my lords have. The honorable members will recall that the government had made certain important policy announcements while introducing the finance bill on 16th March 85. One such announcement was that the companies should be permitted to make political contribution in order to enable the corporate sector to play a legitimate role within the defined norms in the functioning of our democracy, and for this purpose necessary legislation would be undertaken. In recent years, a view has gained ground that a certain amount of openness rather than a blanket ban on political donation will really augur well for a cleaner political and economic environment. Representatives of trade and industry have been equally urging upon the government to reconsider replacement of the existing provision of 239A by the law which obtained prior to 1969 and which was introduced by 1960 to permit companies to make political contributions subject to certain ceilings. Companies often urge, and rightly, that they are entitled to support a political party which believes in certain amount of freedom of private business. Secondly, many companies feel that they can resist any pressure from any political party out of books donations if they are allowed to contribute by an enabling provision of the statute. Please mark this. In 85 also they said that we are required to pay in cash. Black permit us officially. Enabling provision on the statute, a certain sum which is within their capacity to spend. Thirdly, it is also argued with some force that a company itself functions on the principle of shareholders' democracy, and therefore a ban on political donation in a democratic society is an anachronism. Fourthly, political donations by companies is permitted within limits in other democratic countries of the world which have not suffered on account of permitted political donation. Now, your lordships, my lord, kindly rest, my lord, your lordships may not read. Please come to page 43. My lord, this is a beautiful, my lord, speech delivered by one Mr. Panika. Lordship has them. My lord. I'm just showing, my lord, the
What is the internal page on that?
330, right hand side top. I'm showing, my lord, that this is the problem with which we are grappling, and we are trying to find out some solution or the other.
Where does that speech begin actually?
Lord, it's begin at page 326, internal page 320. Left hand side is 325 and right hand side is 326. That's column wise pagination. It seems, my lord. There is a column wise pagination.
Yes.
I am on, my lord, column number 40.
First was Mr. Virendra Patil's statement, which you read out.
Yes, my lord.
All right. And where does Mr. Panika's begin actually? I just want to go back.
No, that is 330, right hand side.
No.
Right hand side. My lord, they have paginated.
Pyare Panika.
Yes, Panika.
From Robert's Ganj. All right.
Yes.
I thought it was KM Panika. No.
No.
Pyare
Sir,
Panika. Yes.
as the Honorable Minister has said while introducing this bill, a hint was given at the time of introducing the finance bill that a bill permitting donations to various political parties would be brought forward. Not only this, the Prime Minister of our country had also announced in the manifesto of our party at that time that the election at the time of elections that such a provision must be made, keeping in view the political parties and also with a view to removing corruption from the country. With all these things in view, the Honorable Minister has brought forward this bill today. Therefore, I fully support the bill. Sir, you just have a glimpse into the history of the 37 or 38 years. A bill was brought forward in 1956. Not only this, the leaders of the political parties of the side, where it was Professor Madhu Dandavate or whether it was Sachar committee, were of the view that donations should be banned, and it was under those circumstances that government had imposed a ban on them. But after imposing the ban, it was felt that black money was increasing rather fast, and various political parties who were not in a position to collect donations either due to their own policies or due to other circumstances of their own making were not getting justice even in the elections. Keeping all these things, this bill has been brought forward. I was just going through the debate that took place on this bill in Rajya Sabha. Many of the opposition members have supported it, but at the same time, they have also alleged that the Congress so-and-so party has brought forward this bill in its own interest. I went to tell Sri so-and-so, you have a government in so-and-so, and left front have their government in so-and-so. The so-and-so has its government. Therefore, if you criticize, it is for the sake of criticism. It's not good. There is no question of benefit in it. The question is how to root out corruption from politics. Today, black money poses the biggest problem before the country, and all this is being done by big capitalists, those elements who influence the economy of our country. And if it is not checked, it is but natural that these elements will try to give a slip to government under the pretext of patronizing many political parties. Therefore, today is a very important day in the democracy of our country, and the bill brought forward by the Honorable Minister is a historic one which will help checking many malpractices which have crept into polity due to the imposition of ban on donations. Not only this, I and my party colleagues are of the view that there should not be too many parties. One knows to what extent the number of parties had risen before the elections in the name of caste, etc. My lord. Please come to, my lord, next page, 334, my lord, the right-hand side pagination. My lord, this is by Harish Rawat, the then MP, possibly, my lord, the former CM of Harish Rawat.
Yes, yes.
Uttarakhand. The political system, my lord, second unnumbered para. The political system which we have today is an open political system. In such a system, every section is free to play its decisive role, but the prosperous section uses its influence more. There is no denying the fact that the role of money is continuously increasing in our election system. Every political party is ever eager to accept this money in some form or the other and from one source or the other. No political party is today in a position to say that they contest election on the money raised through their membership subscription or by the subscription collected by the workers, except, my lord, we have seen one party, my lord. In this situation, which is developing in our country, wherein at the center there is so-and-so government, and in various states, governments of different parties are being formed, it cannot be said that the rising of resources by way of donations is confined to the so-and-so party alone, and there is a restriction on other parties, and that they cannot accept money. That is not so. Now the question arises, why a ban was imposed on it in 1969? When this ban was imposed at that time, also it was serial on the basis of recommendations made in the reports of various committees that donations by companies were causing degradation, a sort of pollution in politics. But after the ban imposed in 1969, a new situation emerged. The intention behind that ban was good, but the intention was not fulfilled, and it was highlighted by the political parties, the intelligentsia, and the newspapers that the political parties were receiving black money from the companies, and the companies were polluting politics by giving black money, and at the same time, the political parties were giving protection to the companies generating black money by accepting donations. I am of the view that the donations that the political parties will get after legalizing donations by the companies will not be in black money. The companies will have to show their accounts to the income tax and other departments, and the other people can also have information to this effect in one way or the other. My lord, please rest, my lord, your lordships can skip and come to, my lord.
This is lacking now.
Yes, I'm sorry.
The present scheme, this is lacking.
Yes, my lord, we
Other persons will not be in a position to get any
Correct, my
information.
lord. I'll have to justify that. I'll have to justify that. But this attempt was made. Thereafter also some attempts were made, and having found that this is the only possible solution to not incentivize black money, then, my lord, the decision is taken. I'll come to that. I bow down, my lord, and I'll have to satisfy your lordship's conscience on that. My lord, page 338, my lord, second unnumbered para. Sir, whatever might have been desirable in 1969 may be undesirable in 1985 and vice versa. According to the particular situation prevailing at that time, we would have decided something. But now, with the change in the circumstances, if we reverse our earlier opinion, there is nothing wrong in it. Everybody feels that even when there was no ban on political donations, the generation of black money was so rampant that a serious check was necessary, because the future of our children and future of our democracy have been seriously affected. Now, sir, the very basis of democracy is that we must have a clean public life and a cleaner political structure. We want to create a society by giving a tradition of cleaner public life about which our children may be proud of. The present situation which is prevailing is that there are serious complaints to which I referred to earlier. Your lordships can, my lord, thereafter skip. Please, my lord, rest may not be, my lord, of much assistance, and thereafter your lordships would find the objection reasons, my lord, why in 1985 this act came to be amended, and 239 was reintroduced, permitting the political contribution, of course, with the cap of 5%. That is at page 62 of this compilation. My lord, it refers to the same thing. My lord, I may not take your lordship's time on that. My lord, kindly, my lord, come back to my written submissions at page 7. My lord, the statement of objection reasons in substance says what I have read, what was discussed in Parliament. Nothing more, my lord, nothing less. So either of us, my lord, may not get any new fact which can assist your lordship. My lord, page 7 bottom. Wide-ranging amendments were made in the Representation of People Act, the Income Tax Act, 1961 and the Companies Act 1956 in various provisions relating to elections, political parties and connected matter. The amendment inter alia included the following. Section 29B was inserted in Representation of People Act, by way of which political parties were explicitly permitted, subject to provisions of the Companies Act, to accept any amount of contribution voluntarily offered to it by any person or company other than government company. The provision for declaration of donation received by the political parties was also inserted as Section 29C in Representation of People Act. My Lord, this is now amended, my Lord. Your Lordships have seen that. A chapter relating to supply of certain material to recognize political parties was also inserted in Chapter 5A in the Representation of People Act. Contributions to political parties by individuals as well as corporations were made 100% tax deductible by insertion of Section 80 GGB and 80 GGC in the Income Tax Act. By way of amendments in the Income Tax Act, this is 2009, tax deductions of the contribution made by a company to electoral trusts were enabled and income received by electoral trusts were also exempted from the Income Tax Act. Then, 2013, the 5% cap was increased to 7.5. Then 2014, guidelines for submission of contribution reports of electoral trusts were issued by the Election Commission of India to requiring electoral trusts to disclose details relating to contributions received by it and the contributions made by the trust to various political parties. Lord, please pause here for a minute. Lord, what is this electoral trust? It exists today also. This system exists today. The Honorable Finance Minister in 2017-18, while introducing the present scheme, takes note of it and says that it has not achieved the result it was intended to achieve. Electoral trust is not the subject matter. I just broadly point out what are the contours of how the trust operates. Lord, any companies, number of companies, 5 companies, not less than 5, my Lord, can create a trust. It's only a name trust. It is not to be registered as a trust. It is a Section 25 company. Whatever companies have chosen to be members of this trust would put their money in that common pool. And that trust would decide whom to pay, what to pay, to what extent to pay.
And they have to pay not less than 95% of income in the previous financial year.
5% would be for their administrative expenses. But there also, this confidentiality was not given. And therefore, nobody preferred to go through the channel of electoral trust. It is available. Look, today, I must tell you, Lordships, there are these channels available. I can still pay by cash. Very honestly, I can still pay by cash. Second, I can pay by way of a check, which discloses my identity. I may not have any objection, my identity is disclosed. I am identified with a particular political party, or I am paying both the same amount, either way. Third, I pay by RTGS. That again discloses my identity if the party wants, any political party wants to know. Fifth, this electoral trust. That also is a scheme open. Now, the fifth one, after experimenting, my Lord, all these, is the present scheme. Lord, please, my Lord, now 15 year losses were taken, my Lord, the Election Commission's report, and my Lord, 2017 are the present amendments, my Lord, which are made, and electoral bond scheme was notified. Now, my Lord, may please kindly see. But at that stage, my Lord, I'm not going to read, just my Lord, I'm highlighting at page 12, your Lordships would find position in the United States of America. My Lord, they also had, my Lord, something similar like electoral trust. Because every country is grappling. For example, my learned friend cited one example of one country where it is directed that government would fund the election. It's not possible. That was an example of a country with less population than Delhi, and with 2 or 3 parties. But we have federal democracy, we have several country-specific issues. But here, what is called PAC, political action committees, which were like voluntary organizations were created. And those PACs were the common pool in which the companies would donate, and those PACs would decide where to, which political party is to be funded. But they had their own problems, which I have narrated, my lord, which may not immediately assist your lordships in, my lord, the present dispute, and therefore, my lord, I leave it at that, my lord. Your lordships may kindly go through it. It would be, my lord, it would be an interesting read, my lord, and it would give a perspective that why every country is grappling with the problem and why every country is trying to find out the solution which is country specific. Now, your lordships, my lord, kindly come to page 22. Race time, your lordships have taken note of several things, my lord. But before that, my lord, please come to para 62 at page 22. But I had the benefit of sitting with the then Honorable Finance Minister, who, my lord, conceived this. He held several meetings, not with me, with several experts, and the scheme was drawn. And when this petition was filed, my lord, he explained to me, to the learned Attorney General, then Attorney General Mr. Venugopal, and me. We sat with him for about 3 to 4 hours. My lord. This is the crux of what he felt. Transparency in, look, this is the Honorable Minister's speech on 1st of February 2017. Page 22, para 62. My lords, have transparency in electoral funding. India is the world's largest democracy. Political parties are an essential ingredient of a multi-party parliamentary democracy. Even 70 years after independence, the country has not been able to evolve a transparent method of funding political parties, which is vital to the system of free and fair elections. An attempt was made in the past by amending the provisions of the Representation of People Act, the Companies Act, and the Income Tax Act to incentivize donations by individuals, partnership firms, HUFs, and companies to political parties. Both the donor and the donee were granted exemption from payment of tax if the accounts were transparently maintained and returns were filed with the competent authorities. Additionally, a list of donors who contributed more than rupees 20,000 to any party in cash or check is required to be maintained. The situation has only marginally improved since these provisions were brought into force. The political parties continue to receive most of their funds through anonymous donations, which are shown in cash. Lord, this is, Lord, unless you accept the problem, there cannot be a solution being found. Lord, honestly, my lord, the then Honorable Minister says that this is the problem we are facing. An effort, therefore, requires to be made to cleanse the system of political funding in India. Donors have also expressed reluctance in donating by check or other transparent methods, as it would disclose their identity and entail adverse consequences. Well, this is not what I am saying by way of a justification. This is what is in the mind of the lawmaker. Fortunately, he was very sick. Unfortunately, my lord, just the out of, not out in the so far as matter is concerned, but when this discussion used to take place, the then Honorable Finance Minister, my lord, was really very unwell. He was in the last phase of Mr. Jaitley, my lord, and he used to carry some liquid, my lord, which he used to continue sipping as advised by the doctors, and we lost about 25 kgs, and my lord, I can remember those days, my lords. An effort, therefore, requires to be made to cleanse the system of political funding in India. Donors have also expressed reluctance in donating by check or other transparent methods, as it would disclose their identity and entail adverse consequences. I therefore propose the following scheme as an effort to cleanse the system of funding of political parties. In accordance with the suggestion made by the Election Commission, the maximum amount of cash donation that a political party can receive will be 2,000 from one person. Political parties will be entitled to receive donations by check or digital mode from their donors. As an additional step, an amendment is being proposed to the Reserve Bank of India Act to enable the issuance of electoral bonds in accordance with a scheme that the Government of India would frame in this regard. Under this scheme, a donor could purchase bonds from authorized banks against check and digital payments only. They shall be redeemable only in the designated account of a registered political party. These bonds will be redeemable within the prescribed time limit from issuance of the bond. Every political party would have to file its return within the time prescribed in accordance with the provisions of the Income Tax Act. Needless to say that the existing exemption to political parties from payment of income tax would be available only subject to fulfillment of these conditions. This reform will bring about greater transparency and accountability in political funding while preventing future generation of black money. Further, the speech of the then Honorable Minister, my lord, there were some apprehensions voiced by some leaders of the opposition parties. Then, my lord, the then Honorable Minister answers. Let me clear the misconception if there is any, because we have gone through this debate at the time of the finance bill itself. This announcement was a part of the general budget itself. I had announced in the budget speech itself that political funding in India needs to be cleaned up. Today, the system is, and this is no secret to any political party or to the world outside, that donations coming to political parties are coming otherwise than through banking instruments. The names of the donors, quantum and source of money are not known. There was complete lack of transparency. Electoral bonds substantially seek to cleanse. Already he doesn't say 100%. He's very clear that we substantially try to tackle this problem. Electoral bonds substantially seek to cleanse that system. Any person seeking to donate money to a political party during that specified period can buy electoral bonds from the specified branch of the State Bank of India. Those bonds can be given only to a registered political party and only such parties, so that fake parties are not registered, which secured at least 1% vote in the last election. Otherwise, for the purpose of getting donation, you can float a party. Those parties will have to announce one designated account, that is so-and-so or the so-and-so or the so-and-so will have one account given to the Election Commission in advance. These bonds can be encashed within 15 days of purchase by the donor to the political party. My lord, when I come to the scheme, I'll explain why this 15%. That quid pro quo element is, my lord, attempted to be done away with. There would be a significant amount of transparency. Significant amount, my lord. It doesn't say that this is a foolproof solution we are giving. Today, there is nil transparency. When the cash is given, the source of money, the donor, and where it is spent is not known. Therefore, at least now it will be known. The donor will be having an account of how many bonds he has purchased. The political party will be filing returns to the Election Commission, thereby indicating the total bonds it has received and which donor gave to which political party. It is in order to ensure that the transformation into clean money takes place smoothly and people are incentivized to give that. That is the only factor which will not be known. So there will be clean money and a substantial.
Mr. Solicitor, there's a clear problem here with this speech.
Yes.
The finance minister then, I mean, it's of course a speech in parliament, but now the element of transparency is that the donors buy these bonds. Not necessary. The donor doesn't have to buy the bond. The person who buys the bond need not be the donor to the political party.
Out of 100, your lordships are right, 2 can be such. Not all.
We are not on how many.
But your lordships
we are not how many.
But your lordships would not.
We don't know how many out of 100 too. The point is that a donor does not necessarily have to be a person who buys the bond at all. Second,
I'll answer that. I'll answer.
Obviously, their balance sheets will reflect that they have bought a certain amount of bonds.
Correct.
Balance sheets of only the purchaser will reflect, not of the donor necessarily.
Correct, Manu. Maybe 3 out of 100, 5 out of 100. No, your lordships are aware I need not cite the law, though I have placed it.
Then later in the next para, the learned finance minister says, when the cash is given, the source of money, the donor, and where it is spent is not known.
Correct.
Therefore, at least now it will be known. How will this be known? Suppose an electoral bond is purchased, the source of the money is not known, the donor is not known, and where it is spent is not known.
I'm sorry.
All three are not known.
No. It is known, my lord. Kindly allow me, my lord, to explain the scheme. My lord, when I buy that, my lord, forget the example which your lordships, my lord, have in mind.
Yes.
Out of 100, my lord, 5 people may misuse the scheme. That
Yes.
may perhaps not be the ground on which your lordship would judge the validity. But rest 95, my lord, those who
We are
really
not on
want to.
misuse. We are on what the scheme really is capable of achieving.
Your lordships have not seen the scheme.
Right.
Lord, nobody has taken your lordships through the.
We'll see the whole scheme together.
Lord, therefore, but Lord, what the honorable minister is, Lord, trying to say is that if I buy the bond, my balance sheet would reflect that I am buying the bond. The scheme envisages that I can buy my bond only if I am KYC compliant, and therefore it would be known somewhere that this gentleman has bought electoral bond for being contributing
The
to.
balance sheet does not reflect which bond he has bought. The balance sheet only reflects the total amount which has been spent
Yes.
on contributions.
The total bond purchased, the amount, not to whom it is given. It need not, my lord. Otherwise also, my lord, it is never. My lord, if I buy, my lord, say Kisan Vikas Patra, not a comparable thing, but it doesn't show. The balance sheet would not show it's gifted to my daughter. It shows only buying of Kisan Vikas Patra. Now, when it is given to a political party, the political party would deposit in a designated account. There is, my lord, a minute scheme which is prepared. And that designated account also will have to reflect in the statement of accounts of that political party, which will be filed before the Election Commission. The Election Commission would know that at least 500 crores have come by way of clean money. And both of them, my lord, will be reflecting that in their respective books of accounts, which the honorable minister says in case of cash, nobody knew. I may go with a bag of 50 crore, give it to Mr. X who is the president or whatever of a political party, and nobody would know what I have given, to whom I have given, whether it has reached political party or not, what use it is put to, nothing. Therefore, he says that significantly we'll be able to tackle this problem. Then, my lord, it is in order to ensure that the transformation into, I'm sorry, my lord, that I have seen. My lord, now, this is wrongly mentioned as article written, but it was a statement made by the Honorable Finance Minister, published in, my lord, Press Information Bureau. My lord, that is, my lord, very, very, my lord, relevant for your lordship's assistance. Your lordships have, my lord, page 24, para 64.
Yes.
My lord, I can read it from the original, my lord, which is at page.
We can read it right here only. You can read it here. No problem. You have extracted the whole of
My
it.
lord, my lord, if I can, my lord, read it from here. We have extracted whole. My lord, it's not extracted in full. My lord, better your lordship reads from the whole. It would be unfair, my lord, not to read the whole. My lord, it's PDF 14, volume 2. Volume 2. PDF
Page 14.
14. PDF page 14. But first and second para we have not quoted because that is already there in the budget speech of the Honorable Minister. Your lordships would find. I'm not reading, but just see, India is the largest democracy in the world. However, despite strengthening various institutions for the last
So it appears to have been an article by Mr. Jaitley, because this also says, following is the text of the article written by Mr. Maybe it was published in some newspaper at that time.
No, it was Press Information Bureau, but my lord, I'll check up. But I was told, my lord, there were some confusions or, my lord, misgivings, and therefore it was more by way of a statement. But be that as it may, undisputably written by the then Honorable Minister. A major step, my lord, second paragraph. Lord, can I? I'm sorry. A major step was taken during the first NDA government. The Income Tax Act was amended to include a provision that donations made to political parties would be treated as expenditure and would thus give a tax advantage to the donor. If the political party disclosed its donations in the prescribed manner, it would also not be liable to pay any tax. A political party was expected to file its return both with the income tax authorities and election commission. It was hoped that donors would increasingly start donating money by check. Some donors did start following this practice, but most of them were reluctant to disclose the details of the quantum of donation given to a political party. This was because they feared consequences visiting them from political opponents. The law, there are governments of other political dispensation in states. So, my lord, that is how, my lord, we balance the side. But it's not only the central government which rules. In a federal setup, my lord, if you, for example, if somebody were to pay BJP in West Bengal, I'm just giving a hypothetical example, then some other party, my lord, might victimize. It's not an allegation, it's an illustration. The law was further amended during the UPA government to I give another example so that my learned friend is satisfied.
It's a very apt example. Why?
My lord, why? Lord, in Madhya Pradesh, somebody contributes to Congress, maybe, my lord, BJP might victimize. Lord, now it balances. Now there is a level playing field between both parties.
No, there is no level playing field on the funding. The rest is the level playing.
No, this was on the lighter side. Some donors did start following this practice, but most of them were reluctant to disclose the details of quantum of donation given to a political party. This was because they feared consequences visiting them from political opponents. The law was further amended during the UPA government to provide for pass-through electoral trusts so that the donors would park their money with the electoral trust, which in turn would distribute the same to various political parties. Both these reforms taken together resulted in only a small fraction of donation coming in the form of checks. Please mark this. This is what ultimately the experience was. In order to make a serious effort to carry forward this reform process, I had announced in my budget speech for the year 17-18 that the existing system would be substantially widened and donations of clean money could be made to political parties in several ways. A donor could enjoy a tax deduction by donating in check. Donors would also be free to donate monies online to political parties. A cash donation to a political party could not exceed an amount of rupees 2,000, etc. My lord. Please see next para. I do believe that donations made online or through checks remain in an ideal method of donation to political parties. However, these have not become very popular in India since they involve disclosure of donor's identity. This is the heart and soul on which, my lord, either I can satisfy persuading your lordships or I fail. The confidentiality.
So the heart really, I mean, that you are, frankly, Solicitor, you're very fair. The heart of it is whether we accept this submission that, look, if you require disclosure of
The
identity.
scheme fails. Then we
Then-
go back to the earlier thing, or
Because
unless
whether we like it or not, according to you, our political system is such that there would be reprisal, that there would be a sense of vindictiveness if that, well, you paid this to this particular party.
and that incentivize payment by cash.
No, there are two aspects to it. One, as pointed out, whether by giving confidentiality to the donor, a greater objective or greater protection, a greater public.
Larger
good is-
public interest is served.
The second is partial confidentiality.
Partial.
What I said, selective confidentiality, yes, that's what my brother is emphasizing.
Because what happens is the person who's in power can have access to it.
I'll show he will not be able to. That's what
That's the gray area. The other side will not agree to it. You may say so, but the other side,
Before your lordship, my lord, if we agreed on.
other side will not agree to it.
Yes, yes.
And coupled with, their case will be coupled with the number of cases against the opposition. You may be justified in saying there's violation of law, therefore cases are justified. Court will also say so.
My lord,
There is a
everything.
statutory obligation on the State Bank of India to maintain that confidentiality. You presume
There is-
confidentiality before their banks are, that's all.
Lord, I'll show that. There is a confidentiality. And when, in a, I know, my lord, what is falling from your lordship. In a raid, my lord,
Thanks for that.
Lord, if in a raid, if we have to go with counting machines, not one machine, then they can.
We are not on that.
We are being victimized.
No. We are not saying.
Yes.
Look, if you come to the court, if there is a wrongdoing, if there is
Yes,
legality.
there are courts, my lord.
They'll obviously not support that. They'll support the right side of the law. But the issue which is raised is if there is selective confidentiality, then what happens? Third aspect which is there is, just third aspect.
Yes.
Because while dealing with the first aspect itself, which is, or the second aspect itself, if confidentiality is given, how do we ensure what was called the protection in one sense, quid pro quo in another by another speaker? How do we ensure that this is checked?
That I have not paid money to get a favor. Well, let me put it as plainly as possible. Well, from the scheme, I'll be able to satisfy lordship. This, my lord, concept of selective confidentiality, my lord, I'll have to remove that there is complete confidentiality. Between the two, there is none. There can be, there need not be. But the government cannot go through that, pass through that and find out from decoding whether my learned friend has given to a party and not me. That I'll be able to show from the scheme. But ultimately, my lord, you will have to trust somewhere. Lord, for example, if everything is to be shown to say election commission, there can be a leak. You will have to trust somewhere. You will have to trust somewhere.
It's not liable to give rise to, say, I mean, possibility. It's a question. It's not a hypothesis of legalizing kickbacks. Because as you rightly said, Solicitor, earlier, in the earlier scheme, what would happen is, say, a rainmaker for a political party, ABC political party. You would collect some money. He collects 50 crores. He's not going to deposit 50 crores in the coffers of the political party. He has his own share in that. Now, basically, the benefit of this, let's look at it, the positives, so to speak. The benefit of it is that you are legalizing whatever the motivation for the receipt of the funds, But now it goes to the party. It doesn't go to the individual. That's the benefit. The party gets it as opposed to the individual rainmaker who would have got it earlier. And we have no way of knowing whether this is really also legalizing the motive for the inflow of the fund.
Kindly see, just, my lord, I'll answer that, my lord, in detail tomorrow.
We got your point. I mean, we'll reflect
I'll
on
just,
it.
my lord, leave
We'll
one
reflect-
thought.
We'll reflect on it, which is your case is that, look, this is the political system, whether you like it or not. Whether we like it or not, this was the political system. This is how it operated. We have at least tried to improve upon it. The fact that we don't succeed doesn't reach out to the constitutional validity of it. Maybe we have not improved upon the system, but we have tried to improve upon the system.
I'm grateful. No, one thing.
That exposes the argument, well, I hope your lordships are talking about his argument.
Yes, that's his argument. No, that's what his, no,
It
we
is-
are formulating whatever.
We can only, yes,
He's also in a lighter vein than I can
we are
say.
very open to everything.
But, my lord, forget this
That's
scheme
why he
is,
pointed out what
No, no,
was,
it's right.
what was the regime before.
That's right, that's right.
no, my lord, forget
Do away
this.
with black money has to be the, Malas, we are all on one platform on that.
Very simple,
Yes.
which I had pointed out, if they wanted to deal
No,
with.
then you have to go to parliament.
No, no.
That way you can't find out
No,
here
no,
as
no.
a public interest.
You
litigation.
allow all this and distribute it amongst all the candidates.
All
Simple.
the-
Allow all this.
Just one more question.
But you cannot
With
impeach the
regards
party.
to the unaccounted, that is to 20,000, now reduced to 2,000, the quantum which has been received by all the parties,
Whatever.
and how it
It
is.
is there, my lord, in the
It's there.
compilation which I have filed, my lord, would
If
your
it's
lordship.
there, then it's fine.
But, my lord, my lord, I'm just leaving a
Percentage.
thought with your lordships, but I'll respond tomorrow. But suppose this scheme is not in existence. I want to give a kickback. I will pay kickback, has to be, my lord, by way of
By way of cash.
cash. Now, even considering the case to be the worst, the amount will come in white money and will come in the official channel, banking channel.
But it's legalizing the kickback,
Yes.
but
No.
giving the money to the political parties as opposed to people who
would
are involved
still
in
be an
the
offence.
That's all.
It would still be an offence. I'll be able to satisfy your lord.
The difficulty may be, because if it's given by the political bond or the election bond, then the issue is, it's all protected under the umbrella of confidentiality.
Yes.
That's the problem.
That's
Now,
the
the first-
heart and soul of the scheme.
That's where
That's the
next
only
part of-
incentive of the scheme.
You know, you can maintain confidentiality,
Yes.
which is to ensure, we take your point, that confidentiality is designed to ensure that people are not victimized for contributing.
And
But
incentivized
if
to
you
pay
really
back.
want- We are not saying that that would be a better scheme or that the government should adopt the scheme. That's not the point. But if you really want to have that scheme and a level playing field, then all these donations should be given to the Election Commission of India, which will then distribute it on an
That's what I
equitable
was
basis.
saying, Malas.
You will realize no donations come
That's
through.
correct. That's
Then,
correct.
then, my lord, nothing will come and everything will be by cash.
You're absolutely
what I
right.
was
That's
saying.
what exactly we said. Which shows us the motivation for these
Yeah, yeah.
donations.
Obliged.
Tomorrow we'll continue.